Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have 4 cases on for hearing this morning. The first is 23-1541, Gelin versus Baltimore County. Mr. Neitzel.
Thank you, Your Honor. May it please the Court, the United States District Court committed error when it denied qualified immunity to the corrections officers here in a case involving the suicide of an inmate. In order to be denied qualified immunity, the officers would have had to have violated a clearly established right, and a fair description of the right at issue based on the well-pleaded facts is the right to be protected from suicide even when the officers have no knowledge of any substantial risk of suicide. The facts here indicate, in fact, not only did the officers not know of any substantial risk of suicide, that first of all, there's no knowledge that they knew much of anything at all about the mental health of
Counsel,
yes.
before you get to the merits of that, can we talk about some procedural matters first? Slightly different than the issue we asked supplemental briefing on, but related. It appears to me the notice of appeal that was filed mentions or references the April 13th order letter as the order being appealed.
Yes.
Not the March 13th order. So I'm trying to understand how the appeal is timely. It's more than 30 days after the March order. Normally, motions to reconsider aren't immediately appealable. I know you've characterized the motion not as a motion to reconsider, but a Rule 52 motion. The district court said it was not and construed it differently. If the district court was right that it was not a proper Rule 52 motion, do you have a timeliness problem?
Well, Your Honor, about that, I think I did make an error in bringing it under Rule 52. And I think the district court was actually wrong also. It's not a Rule 54 either. It's a Rule 50. It should have been a Rule 59 motion. Because the way Rule 54 defines a judgment, it defines a judgment to include an order from which an appeal lies, which would be an order denying qualified immunity. And as to what the notice of appeal says, this court has repeatedly not simply rested on the formality and the formalistic, but rather what the intent of the appellant was, based, for instance, on the briefing. This court has said that in multiple decisions, and it's clear that the intent of the appellants was to appeal the actual denial of the qualified immunity. And also, this court has repeatedly, again, not rested on what the appellant says the rule was, but what it should have been. In other words,
the timing of the, let's assume it's a Rule 59. What was the timing of that motion?
it was filed on the 28th day. So, and under Rule 59,
28 days.
28 days, yes. I purposely did that, and in fact, I waited as long as I could. And I actually waited as long as I could on 30 days for the appeal because I was waiting to see if the court would actually rule on the public official immunity issue.
And I looked at the timing of the 28 days and agree there. So for this to be timely, it should be construed, your position, as a Rule 59 motion?
Yes, because under Rule 4 of the Federal Rules of Appellate Procedure, it explicitly states that a Rule 59 motion tolls the time to note an appeal.
But why is it a Rule 59 motion when there's not a judgment? You may have, that may be proper, but I I think a Rule 59 motion, I think by its terms applies when there has been a judgment issued or rendered. Here we have an order that expressly doesn't do that. It denies your motions to dismiss, and no doubt you have a right to appeal the qualified immunity issue. There's law on that. But I'm not sure I understand why 59 is the right way to
And
look
obviously,
at it.
at first, I made that mistake myself because I filed under Rule 52. But because if you look at Rule 54, there's a definition section at the very beginning of Rule 54, and it defines judgment. And one of the definitions of judgment is an order from which an appeal lies. And an order denying qualified immunity, an appeal lies from that. In fact, in this court, in Campbell v. Galloway in 2007, it's 483 F. 3rd 258, 266, note 2, the court actually says in passing, the magistrate judge addressed the qualified immunity question in a separate order after the defendants filed a timely motion under Rule 59 of the Federal Rules of Civil Procedure.
So the link is you have a judgment under Rule 59 because Rule 54 says an order from which an appeal could be taken is considered a judgment?
Correct. I don't know why the definition section is in Rule 54 and not somewhere earlier in the rules, but that's where it is.
Right.
And there's case law that says that. It points to Rule 54's definition of what a judgment is, and it includes an appealable order, which this would be. It was my mistake for not citing Rule 59. Again, in this case, as to the merits of the case, there was no indication in the record that the officers here even knew about...
That's not the issue, is it? I mean, I'm not taking away from that. You probably gain a lot of mileage if you're right on that, but it seems to me the medical caretakers are not in the case. And so we're only look at the complaint and its allegations against the prison officials. And the allegations of the complaint make two allegations as far as I can tell, and of course I'll direct this question to your colleague too, but as I understand it, number one, there was a fight that Gelin had with her inmates, and the allegation is because of that fight, the guard should have put her in a different cell. And number two, that when she screamed, no one came. But there's no allegation that they heard the screams. And so those are the two allegations, and the question is whether those two allegations constitute a cruel and unusual punishment under the Eighth Amendment, which, of course, requires established law, it requires a mens rea, and it requires various other elements of establishing. It seems to me that's where your argument is, as opposed to focusing on whether the guards knew about the suicide, because there's no allegation that they are imputed or are responsible for that.
Well, in that case, I think that the case is even stronger.
Well, it may or may not be, but you may be right, and maybe by inference, the prison officials recognizing somebody has a mental health problem, but I suspect that many people who have been detained or who are sentenced have mental health conditions, and the prison officials probably know it, but is there any case that says they have some kind of duty to do something unless there's a request or some problem, somebody's hurting himself and the guards know about it, they need to put him under suicide watch or something. But here the allegations are against the medical caretakers who are no longer in the case. And so when you comb the complaint to see what's against the prison officials, I think those are the allegations that I was able to call, and I'm going to ask your colleague about it too. But I thought the two things were, one, they didn't move her to another cell, and number two, they didn't respond to her screaming.
Well, there's two issues, Your Honor. First of all, I'm not aware of any case law that says that if you get into a fight, it's deliberate indifference not to put you in a special cell. I'm not aware of that. And the other problem factually here is she had already been diagnosed with a mental health disorder. And as the plaintiffs allege in their, and this is in the records, this is page 149 of the joint appendix, under the detention center policy, once you have mental health issues, it's medical staff that determines how you're housed, not the guards.
Yeah, but we're not resolving facts. I mean, the difficulty I have with a lot of these cases, is we got to go back to the fundamentals. I mean, you already addressed a procedural question, which was pretty serious. I think you did have probably a 59, and you didn't label it that way, but a Rule 59. But here, the allegation is the guards are charged with conduct which is alleged to be violating the Eighth Amendment. So the very first step is say, what conduct are they being charged with? And show me in the complaint where they charge the guards with having to take care of the medical condition. I thought they said the guards should have moved her after the one incident where she had a fight with her colleagues there in a prison. And the second one is she screamed and they didn't respond. I think that's the allegation. Or no one came. No one came. She was screaming and no one came. That's the allegation. But maybe there's something else. But I don't think they alleged that the prison officials had to take care of the medical condition when it was already being taken care of by the medical staff.
Well, I do think that there are multiple allegations blaming the suicide on the guards for not moving her. I think that's...
Well, that's my point.
Right.
That's right. That's the first allegation.
Right.
They didn't move her after the fight, but the real question is, when she has a fight, do you have to move? Is there case law that says, or is it deliberate indifference? Is it criminal recklessness is what Farmer used as the intent
Right.
For not moving her to another cell?
And I think the answer is no, there absolutely is not. There's no case law that says simply not removing her to a special cell, and that at that point would be deliberate indifference. And as to the screaming, that again is fairly characterized as, again, failing to prevent her suicide. But again...
But that isn't what the allegation is. The allegation is she screamed and no one came.
Right.
Nothing else.
Right. But I think legally that can fairly be characterized as the theory being they didn't prevent her suicide by failing to respond.
They didn't say she didn't fail. They didn't say that prison officials heard her.
Exactly.
In other words, if they said the prison officials heard her but laughed and decided, oh, she's just a screamer, and didn't go, we have a little bigger problem. But the complaint basically says she screamed and no one came.
And I agree with that. And I think under those facts, again, that's not deliberate indifference.
Can I ask, as a follow-up to that, if we take the complaint in the light most favorable to the plaintiff, is it plausible to infer that if someone is screaming in a jail cell, that someone, an official, must have heard that? At least that inference might be reasonable?
I don't think so, because I think it's, again, the burden, I think, is on the plaintiff to plead facts that would make that inference reasonable. For instance, say they could have pleaded that, that these cells were located where guards could have heard them. They didn't do that. They could have pleaded, I'm trying to think of something else that they could have pleaded, but merely pleading, oh, they screamed, that's not enough to then take the inferential leap that, and especially in a prison environment, that where people scream all the time. I think that's a reasonable inference also, that sort of behavior is common in a prison if we're going to do that reasonable inference.
Well, I guess the problem for the plaintiffs is that they're not in a position at this stage, because no discovery has been taken, to know, right? So it's a difficult position for the plaintiffs to be in.
Well, actually, there's extensive written discovery in this case.
Okay.
And in fact, that's why they attached all of those prison records. But again, they could have simply pleaded that. They could have pleaded that they didn't hear it based on the discovery, and they didn't do that.
The counsel, assume, just for the sake of this question, that it's a reasonable inference in the way it's pled that someone heard it and didn't respond. In qualified immunity, isn't the first issue we have to do is characterize the right at issue? And the district court characterized this right as a right of safety, for an inmate. And it seems to me that's where we have a problem. I'm not aware how that right is specific enough that we can use it as the basis of a qualified immunity decision. And so we have to really have a right that is more tailored to the facts based on what the Supreme Court's telling us. And I think that's your point. There's not if we do that, there's not a right that's been clearly established here, maybe even in the construing the facts that way, although maybe it's a tougher case.
I think that's correct, Your Honor. I think, as I cited in my brief, this court, Supreme Court, have repeatedly said you can't draw that right too generally. It has to be specific. And in fact, there also, it's been said by appellate courts, there is no general right to safety of an inmate. They say, that simply does not exist. And I would like to leave the court with this quote from the Gordon case, Gordon v. Kidd, where it says, in the absence of a previous threat of or an earlier attempt at suicide, we know of no federal court in the nation that has concluded that official conduct in failing to prevent a suicide constitutes deliberate indifference. There was no such previous threat of an earlier attempt at suicide in this case.
Let's say that we agree with you that the officers were entitled to qualified immunity, which would immunize them from liability under federal law, but you've got these state law claims, and you say that with respect to the state law claims, public official immunity would insulate, would prevent them from being sued. Is that your position?
For the negligence claims.
Okay.
In Maryland, it only applies to claims based on negligence.
But is it an immunity from suit or an immunity from liability? Because that matters, doesn't it?
Well, I think in I believe in the Nero v. Mosby case, this court has construed that right, those immunities under state law as immunities from suit. So even though that they would not be immediately appealable in a state court, they would be immediately appealable in this court.
But, I mean, Maryland codifies this particular immunity as immunity as an official or individual from any civil liability, which seems to run counter to the notion that it's an immunity from suit. I mean, those are two distinct concepts, right?
I agree. If you rest solely on the codified language, I believe that's true. But again, I think the Nero v. Mosby case, I think this court construed it as an immunity from suit. And that decision still stands in this court.
But to follow up on that, the Dawkins case from Maryland pretty clearly says that there's no immediate appeal, at least under Maryland law, for either governmental immunity or public official immunity.
Right.
So, I mean, it seems kind of odd for us. I mean, Maryland is telling us through that you can't collaterally appeal those decisions involving those issues. So how can they be immunity from suit if Maryland doesn't let you immediately appeal them? I mean, the effect of that is the practical effect is they're not immunity from suit. They're immunity from liability because you can't appeal them to the end of the case, right?
In state court, that would be true. But in my understanding of the way the federal court treats that under federal procedure is they don't necessarily follow the state court's review of whether they're immediately appealable. And because we're in federal court, then the court construes it differently. And I think in Nero v. Mosby, the court said that those immunities were immediately appealable in federal court, despite...
In this case, that issue hasn't been decided yet, has it?
The public official immunity, governmental immunity was.
Well, let's keep straight again. I mean, we're back to the procedure issues, which are very important in these types of cases.
Right.
All the federal claims would be subject to qualified immunity, right?
Correct.
But the state claims the immunity has not been decided yet.
Correct.
So if we were to agree with you, we would grant, we would allow the immunity for the federal claims, but that wouldn't resolve what's still pending before the district court, would it?
Well, the public official immunity, I just want to point out again, the governmental immunity, which adheres to the county, that actually was...
Well, the governmental immunity, yeah.
That was decided on
Yeah, I'm talking about
incorrectly.
Public official immunity for the guards under state law. Now, just to carry the procedural issue further, if we were not to decide that, just to decide the federal claims, the federal claims would disappear, the claim against Baltimore County would disappear, and you would have state claims only on which you have raised immunity, which has not yet been decided.
That's correct.
Now, at that point, at some point, the district court could then decide whether it wanted to exercise supplemental jurisdiction and send it to the state courts. Or it could certify it, or it could make the decision on it. But it seems to me there's nothing to appeal here on that immunity, is there? The court hasn't indicated it's not going to grant it, has it? It has not denied it.
The court did not rule one way or another, no.
Yeah.
Is that right? I thought the public, I thought the court ruled on government immunity, I know you've already said that, but on public official immunity, I thought the court said that the plaintiffs have adequately pled gross negligence. So if there's that, we have a ruling, I thought, that, and if there's gross negligence, public official immunity doesn't protect the defendant, right?
Under Maryland law, that's correct, yes.
So what we don't have is a ruling about ordinary negligence, which seems, we raised it, I had an issue there, but the more I think about it, it seems kind of peculiar. Admittedly, it's not been resolved, but the Maryland law is clear that you do have immunity for negligence. So isn't the only question whether there's been an adequate pleading of ordinary negligence?
Well,
I mean, I granted there's no ruling that addresses ordinary negligence, but the implication, it seems pretty clear that there is public official immunity for ordinary negligence. The district court said you've adequately pled gross negligence. You may challenge that. I understand that challenge, but that's, I mean, the district court said they've adequately pled gross negligence. So why isn't that in effect a ruling that you don't have public official immunity?
I think that's fair, Your Honor. And I challenge the gross negligence finding, but I think if the court were to conclude that the district court was right, that these well-pled facts.
Well, what hasn't been decided then? If Judge Quattlebaum's right about this, then the issue is before us.
I think that's true, Your Honor. If you construe it that way, yes, I think that's fair.
We're not construing anything. We're just reading the order. It says there's adequate.
Well, you're construing in the sense that there was no explicit ruling on public official immunity. It's kind of a backdoor. Well, you have gross negligence negates public official immunity, so if the court has already found gross negligence, then in effect.
Well, there's no dispute that they're government officials. There's no dispute this discretionary conduct. So,
Correct.
one more question on it before
Yes.
we sit down, if you don't mind. So, even if the district court has ruled on governmental immunity and public official immunity, if Maryland, I mean, do we still have this issue of whether they are properly before us, if they're immunities from liability only?
Is the question, if you find qualified immunity, can you then decide that the public official immunity should be sent back?
Or the governmental, for that matter.
Yeah.
I mean, normally, we can consider issues, if we have,
Right.
if we have jurisdiction over, for example, qualified immunity, we can consider pendent claims. Now, I'm not sure these are pendent claims. So, and if Maryland, if they're not pendent, just for the sake of discussion, then it seems like, why would we be considering even reviewing the governmental immunity? Now, maybe that's immunity from suit. I know your argument is under federal law, that's how we look at it. Isn't that the question we must decide? If it's immunity from suit, we decide it. If it's not, and it's not pendant, we wouldn't decide either one of them, would we?
That's fair, Your Honor. If you conclude that it's not immunity from suit, then you would not.
And clearly, under Maryland law, it's not immunity from suit. We'd have to say, we look at it different.
Yes, it's not an immediately appealable order in state court. That's correct.
What's the case that says we should, if Maryland law decides it's immunity from liability, we can decide as a matter of federal law it's immunity from suit? That seems like a remarkable thing, but it sounds like we've said that.
As far as I read the cases, Your Honor, obviously, I could be wrong.
No. What's the case? Is there? Do you mind? Is that or is that in your brief? I'll look at
It
it.
should be in my
Neuro-
brief, yes. There
Neuro-
are several cases.
Neuro, okay.
Yes.
I suppose we can unsay it, but we'll see. Thank you very much. Mr. Wine?
Good morning, Your Honors. May it please the court, my name is Michael Wine. I'm here on behalf of the appellees, Mr. and Mrs. Gelin. I want to briefly talk about, there's actually three different issues to look at in this case. Two are procedural, one is on the merits. The first is whether or not there is any actual jurisdiction in this court, because there really is not a full and final judgment from two or three different avenues or viewings. If this court's decision of al-Shamari, which was a en banc decision involving very complicated issues of federal contractor immunity, that appears to be on point. However, that decision has not been adopted specifically in other reported or published opinions of this court.
Let me just understand the issue, what you're addressing. The qualified immunity of the officers under federal law is appealable. I mean, there's nothing to, the Supreme Court has said it, and we've done it in about 3 dozen cases or more.
Well,
So I don't want to, you can make your argument on that, but I think that's a dead end. The question, more complex question, I think, is whether we review these immunity from the state claims.
well, before I get to what Your Honor just asked, I want to be clear. I was pointing out that al-Shamari, which says that there has to be an actual final judgment specifically on an interlocutory appeal, actually has to be a full and final judgment. And as Baltimore County appears to concede, they acknowledge that there is no.
No, this is an interlocutory appeal, and any single officer can raise it at any time. I mean, not any time he could waive it, but it seems to me when an officer has been sued under federal law, he can claim qualified immunity, and if the district court denies it, he can appeal it immediately because the immunity is immunity from suit.
I would respectfully disagree for two reasons, Your Honor. First of all, if you look back to Cohen, it actually talks about the purpose, even on that narrow Cohen doctrine, is to disallow appeal from any decision which is tentative, informal, and or incomplete. And I'm not trying to primarily just argue that it's an incomplete, tentative decision, but it is. And all the cases that have come out since Cohen.
What's incomplete about it?
So what they did, and this was talked about originally with counsel, is they filed essentially a motion for reconsideration. They called it a Rule 52. The court found it to be Rule 54. It seems to be now a concession that it's 59. And they appealed it even when their motion for reconsideration was still pending. The court denied most of it, but said, you know, I would like to get more clarity and give more clarity and allow more briefing for both parties. And yet, as soon as that order was issued, or at least within 30 days.
So let's assume they had not filed that motion for reconsideration and simply filed an appeal of the order denying qualified immunity. You don't contest that that would have been.
I would not be arguing al-Shamari. I would not be pointing out
So,
the.
I mean, this is just a timing issue, I guess. The question is, what did the notice of appeal actually appeal from? Was it the motion to reconsider or the initial motion? And that's what we were talking with your colleague about.
And there are actually more issues beyond the question of jurisdiction, because the Waltz guy's case talks about this as well, because they filed a notice of appeal. In that case, it was a little bit, instead of first, it was second. They didn't properly do a notice of appeal. And in that case, it's at, I believe, it's a new case, so it's at 11 through 13.
What's the theory? What's your argument? I don't understand your argument. The court made a decision that there is no qualified immunity and set aside the timing issue right now. That's the issue before us. The court decided there's no qualified immunity under federal law for these officers.
Right.
And that's appealable. Now, the question is, you argue it's not. I want to understand don't give me a case, give me your theory. What's the principle?
Yes, Your Honor. This was also discussed by, I believe, Judge Portalbaum and a little bit Chief Judge Diaz. Maryland law,
I'm talking about federal law.
well, yes, that's the Gray Hopkins case out of this court, and that was discussing in detail.
Please don't discuss a case. Tell me the theory why
Right.
the qualified immunity ruling is not appealable. Give me what your reason is. Don't cite a case.
All right. The original basis of the qualified immunity, if you're going to go and use Maryland as an example, is Maryland would not allow this appeal. They have.
This is federal law
A court-
and federal qualified immunity, and Mitchell versus Forsyth has ruled that that is appealable because the immunity is immunity from suit. And to go any further, you're violating the officers'
And
rights.
I have two responses. One is I was just pointing out that there is a disconnect in this court, the circuit's case law. The only case that has cited to Dawkins, even though that's the seminal case in Maryland, is the Nero
This is
v.
not
Mosby
Maryland
case.
law. I'm talking about the federal law. You filed an Eighth Amendment claim, didn't you?
My clients did. I'm on appeal.
And the court denied qualified immunity under the Eighth Amendment. And the question is, why isn't that appealable?
Yes, and
This
again,
is not a Maryland issue. This is federal law under a federal claim.
I understand, Your Honor. I'm just pointing out that there is an inconsistency or something that has not been directly dealt with because the Gray Hopkins case said that Maryland would actually not allow for would allow for interlocutory appeals, and actually they reversed the Hogg case in their decision of Hawkins. And
Based on, but what immunity are you talking, are you confusing qualified immunity with public official immunity?
I'm just pointing out, Your Honor, that
Those are two separate immunities. We're talking about
Yes, Your Honor.
qualified immunity. Do you dispute that, but for this issue of the timing of the notice of appeal, if the officers in this case had appealed a adverse judgment with respect to qualified immunity, do you dispute that that's a proper appeal? And if so, why?
if they had timely appealed it, I would say, I would still be making the other arguments, but I understand that there is other case laws such as.
Well, that's all that Judge
Yes.
Niemeyer's asking you. I mean, so-
But here, with all due respect, I mean, this case was set forth to go into discovery for the first time, 7 years after it was originally filed. And if you look at the decision of which they cite, the Baltimore County cites of Behrens, I'm maybe not pronouncing it, Behrens, it's the United States Supreme Court case. That was from 1996. What that talked about was, it was the Ninth Circuit's decision which allowed for more than one interlocutory appeal. The Ninth Circuit said, you've already got one interlocutory appeal, you shouldn't have to go and do it multiple times. That was the only circuit. The United States Supreme Court says there's no specific preclusion of it. But what's notable, and this is in a footnote earlier in the case, is in Behrens, there was only 5 cases ever that the United States Supreme Court could find where multiple interlocutory appeals are going and being sought at. That was 1996. I would.
What's that got to do with this case?
Well, a lot of these issues, Your Honor, and certainly the predicate,
The one issue, I'd
involve
like to
policy.
I'd like to settle the one issue. I can't understand what your argument is, why a ruling on qualified immunity under the Eighth Amendment is not immediately appealable, and whether, set aside the timing, is not appealable in this case. And I haven't heard your argument why it isn't.
I would have to go and rely on the briefing, which says that, number one, there is this inconsistency in terms of federal law interpreting Maryland law and the policies involved. However, in my supplemental
Because
brief.
Maryland law doesn't follow federal law, we shouldn't apply it in
Well,
federal
not
law?
quite, Your Honor. Federal law said we anticipate Maryland law is going to say X, Y, and Z. A decision came out a year later that found the exact opposite. And it was understandable that the visiting judge in that case would find it because they overruled this case called Hogg, H-O-G-G. So at the very least, I'm pointing out that there is a inconsistency, discrepancy, a need for harmonization if this court is going to find that these cases that began 25 years ago with, again, and also the United States Supreme Court cases that began developing around that. Secondly, towards the end of my supplemental brief, I pointed out there's a distinction in other circuits, which I don't think this court has actually fully addressed. It allows for a much more nuanced but deferential treatment for findings of fact by the trial court. Because when the trial court says, hey, well, this is what I found, we're going to need to have discovery, in other circuits, that's a much higher bar. When they've done that, in order to go and have a proper interlocutory appeal, I believe, in the Second Circuit and in the Fifth Circuit, they have requirements. And that case law, or just, again, it's not a change from this court's law, assuming what Judge Niemeyer, you're correctly quoting everything, and you don't want to go back to the point I'm making originally. There should be an opportunity to go and clarify what is the Fourth Circuit law when the, and what needs to be done if a governmental entity, which is, is a repeat litigant in this court, doesn't unduly get around the federal district court's findings. And I believe there are cases in the Second Circuit and the Fifth Circuit that go and have a much more deference to it. There has to be, you've got to go and say, oh, okay, you can't disagree with the factual findings, you can't disagree with the arguments that are pled by the plaintiff.
Mr. Wine, I think we might be better served if we moved on to, let's assume that we don't agree with you and we think that this appeal is properly before us. So tell us why you think the district court, tell us why you think these officers are not entitled to qualified immunity.
Yes, thank you, Mr. Chief Judge. I would point out that in Appellee's brief in this case, my office quoted directly what was argued by the plaintiff's counsel at the trial level and what was found by Judge Copperthite. I hope I'm pronouncing his name correctly. And there was a long list of about, I'd say, 14 specific findings of fact that Judge Copperthite in everything, in denying, he actually granted the motion to dismiss on a fair percentage of the case, but he denied it on other parts. And amongst those are what was talked about earlier. Number one, there was a major altercation by the young woman with other inmates, and yet they didn't go and move her or ensure that there was proper safety. And
Before we get to that, so tell us, related to Judge Quattlebaum's question, what is the right at issue that you think implicates the Eighth Amendment and shows that these officers were deliberately indifferent?
And I can't say 100% because there hasn't been discovery. That's, I think, part of the point.
Well,
But you have to, you can't
Oh,
say
okay.
that. You
I'm
have
sorry.
to have a theory of the
I
right. That's
misunderstood,
your obligation.
Your Honor. Yes, they have the right to safety, and particularly after being notified whether or not they should or should have not have, known about it. And there are pled arguments, and the supplemental briefing points this out. I'd say 5 or 6 times during the actual amended complaint. Not just that she was yelling, it was actually also, I think, more the inmates were yelling. They were going and banging the walls, they were screaming. No one replied, no one came. And this is in a jail situation. So what my colleague is contending as well, it may not be enough for Eighth Amendment scrutiny. Well, unfortunately, we're still in discovery. This is on a motion to dismiss. It would be nice to go and have who exactly were the who were the employees on that day, what did they hear, what did they see, why, how long of a response there was, whether there were other inmates who were screaming. That's what they were screaming, that this woman was about to commit suicide.
The issue for us is because qualified immunity can be appealed at any time, including from a motion to dismiss or Rule 12 motion, it's your obligation to identify a right that implicates the Eighth Amendment, and then to tell us how that right is clearly established. And if you want to stick with the right to safety, that's fine, but that's a pretty tough hill to climb given its breadth in Supreme Court law.
Again, I'm trying to say that the court's findings, I believe, were fully accurate, but what I would say is that there is, the right to safety, right to not be dealing with undue injury. There was a recent case out of this court that kind of discussed other aspects of a suicidal individual, and it wasn't directly on point, but it did expand it to, I think, like an objective type right. And what I would say on that is
Well, what are the allegations in the complaint that these officers knew that your client was suicidal? I didn't see that.
well, again, we're at the complaint stage, but I believe what they said was it gets intermingled with what the medical personnel. There's no doubt
That's the
about it.
problem. The medical
Right.
folks are out of the case. You're left with the correctional
Right.
officers, and as best I can tell, there's no allegation that these correctional officers understood that your client was suicidal. They may have understood that she had some mental health issues, but those are two very different things.
And again, had Baltimore City not done this particular interlocutory appeal, there would have been discovery, as the court had ordered.
Of course, the qualified immunity is intended to provide protection from discovery. The Supreme Court's expressed that. In other words, if an officer is entitled to qualified immunity, he should not have to go through discovery. They've used that express procedure.
I understand Your Honor's point on that. I would point out that the original basis upon that, when you look at Cohen, I'm not as sure. But I understand, of
Counsel,
course, the Supreme Court in the 80s and 90s has had cases that allow for that.
Counsel, could I shift gears to the gross negligence issue?
Yes, sir, of course.
As I read the district court's order saying that you have adequately pled gross negligence, it said that the basis of saying that was sufficient were these allegations. One, that the officers refused to rehouse your client or your client's deceased after the two altercations. And then the district court said, which I think is accurately in the complaint attributable to the officer defendants. But then the district court said that Ashley had complained that the inmates were screaming her name. But as I read paragraph 50, the allegations of that, 49 through 51, the only report she gave that the inmates were screaming her name was to the correction officer Schumann. And then the district court also said that she was crying, screaming. She complained about crying, screaming, and hearing voices. And the same thing, the only thing you pled that she reported that to was defendant Schumann. So my point is, when I look at what the district court said you pled that justified gross negligence, except for the altercation, it looks like you only pled those as to defendant Schumann.
Your Honor, the trial counsel, it's at Joint Appendix 168 through 173, listed the various findings of Judge Copperty, including what you said, that the correctional officers heard she was crying, screaming, and complaining of hearing voices.
But you didn't plead that. My question is, that's what the order said, but we're reviewing that order. And if the allegations about crying and screaming and hearing voices, as serious those may be, are really things that the plaintiff only pled as to Schumann, that might be erroneous.
Your Honor, again, the trial judge had this. He also mentioned, I believe, and I'm quoting my brief at page 37, the plaintiffs also alleged that the correctional officer defendants deliberately ignored the pleas of other inmates who, apparently aware of Ms. Gelin's impending death.
Where's that alleged in the complaint?
It's apparently quoting paragraph 59, Your Honor.
But
Were continuously screaming while banging on the cell walls.
No, you said deliberately. You used the word deliberately.
I think that gets to the point, Judge Niemeyer's question, if you actually look at 59, it doesn't allege that the correction officers heard her and ignored it. So perhaps, as Chief Judge Diaz said, we're supposed to infer that, but it's not pled.
But respectfully, again, if we're going to have multiple interlocutory appeals, I don't think that the court is wrong in saying that's a reasonable inference. If someone is screaming and yelling and multiple other inmates are doing this, it is a proper focus of discovery to find out exactly what was said, how long they were saying it, did anyone respond, all of that. None of this is in the record because there's not been discovery. I see my time is up. I would like to briefly close unless this court has any further
Go ahead.
questions. Your Honor, this is of course a tragic circumstance. Ms. Gelin and Mr. Gelin, their daughter died. They filed it with counsel in 2016. It still has not, for various reasons, including this, got past discovery. I don't think necessarily, if this court agrees that there is an improper interlocutory appeal, it's not timely because of the notice of appeal as well under Wall's guise, we would ask this court to hopefully ensure that this case at least goes through discovery. So these issues that the trial court found, which is typically when the trial court finds there are sufficient facts, the appellate court should not have to intervene, and this court shouldn't have to go and intervene while a case is pending, while there's still orders that are pending. This case has multiple avenues to potentially reverse, but we would ask this court to consider if it's just a technical reversal, but jurisdictional reversal, to at least ensure that there are not 3 or 4 interlocutory appeals for the clients, and just allow for this case to proceed through discovery.
Thank you, Mr. Wine. Mr. Neitzel?
Judge Quattlebaum, as to your point regarding Officer Schumann and the crying, screaming, and hearing voices, I do note that in the very records that are attached to the pleading, it indicates, this is on Joint Appendix 94, that having been made aware of that, Officer Schumann then referred her for an evaluation by mental health. That surely cannot be gross negligence. And it says per custody request, she was evaluated for crying, screaming, and hearing voices. That's on page 94 of the Joint Appendix. He did what he was supposed to do once he was aware of that.
But is Schumann a correctional officer?
Yes, he is.
Okay,
Yes.
I'm sorry.
I know it's hard.
was
There's so many defendants, it's sometimes hard to, yes, he's one of the corrections officers.
Okay, I misunderstood that. I thought that was one of the healthcare workers.
No, actually, no, Your Honor, I take that back. He is a mental health, I'm thinking of Salisbury, Officer Salisbury. That's who I was thinking of. Yes, Kyle Schumann, he was a clinical social worker. He's the one that interviewed that. But the Joint Appendix 94 says per custody request for crying, screaming, and hearing voices, Kyle Schumann evaluated. So it was clear based on that the officers referred her to evaluation because of that. And that's really the only time that in the entire record where there's any indication that any of the officers knew anything about her mental health. As to the appealability of the public official immunity and governmental immunity, I just want to direct the court to the footnotes on page 19 and 23 of appellant's brief. Citing, there's actually Maryland case law that says that both of those immunities are immunity from suit. And because of that, in the Nero v. Mosby case in 2018, this court concluded that public official immunity is immediately appealable under the collateral order doctrine because of Maryland state law. That's all I
Which
have.
case was that?
That was Nero v. Mosby. It's 890 F. 3rd 106 from 2018.
Is the immunity from suit decision that you referred to after the Dawkins case?
What year is the Dawkins case? I confess I don't remember that.
Yeah, I'll have to get that out. I'll try to find that myself.
That was 2003.
It is. There was a case from called Live Save v. Baltimore County in 2004, which said that public official immunity is immunity from suit.
Even though you can't be.
Unless there's any questions, that's all I have, Your Honor.
Thank you very much, Mr. Neitzel. Thank both counsel for their arguments. We'll come down and greet you and then move on to our second case. second case is 23-6604, United States versus Shanton. Mr. Patel, good to see you.
Good morning, Your Honors. At issue in this case is whether Maryland robbery qualifies as a violent felony under the Armed Career Criminal Act. It does not after Borden versus United States because it can be committed with either the negligent or reckless use of force. Indeed, Judge Walton of the D.C. District Court concluded exactly as such upon carefully analyzing Maryland law, and this court should follow. And specifically, Your Honors, there are 3 points that are critical to the analysis here. So starting with the first point, it's undisputed that Maryland robbery can be committed with larceny plus a battery, and it's undisputed further that Maryland battery can be committed with the reckless use of force. Therefore, it follows that Maryland robbery can also be committed with the reckless use of force. Now, absolutely critical, Your Honor, to the analysis is this court's decision in United States versus Red, because there, the court used the same reasoning to conclude that Maryland first-degree assault fails to qualify as a violent felony. There, the court reasoned that because Maryland first-degree assault can be committed by a battery, and because battery can be committed by reckless use of force, so can Maryland first-degree assault.
So I think I understand the Red case and your argument that is similar. Maybe a difference, maybe it doesn't matter, is that the offenses there were codified, so we had a little more clarity or basis for that kind of 1 + 1 = the result. Here, it seems like to me that, I get your argument, I understand how we do that, but it seems to me the question is in deciding whether robbery can be committed by reckless battery, we have to decide whether we look at the cases, all cases involving battery, or whether we look at the cases involving robbery that discuss battery. Because if you look at the cases involving battery, I think you're right. There are cases that say it can be committed recklessly. So, but in the cases where Maryland has addressed robbery, it's discussion of battery. I'm not talking about just the fact that it's intentional. It's actually discussion of battery uses words like applied force, and has the battery, even the Snowden case, has battery with violence. And so it seems like we have a fundamental question of do we look at the battery cases that don't involve robbery and count those, or does Maryland treat battery in the robbery context different? And it seems to me that's the fundamental question. If you look at them all, you're right. There's some the cases talk about recklessness. As you answer that, I know it's a long-winded question, but it feels like our Johnson case, while it's a different issue, it's about the degree of force, kind of is instructive that we don't do this mechanical approach like we're doing, like you're suggesting.
Well, Your Honor, but the syllogistic reasoning there in Martin Johnson was critically different. So there also, you're correct that we were arguing that Maryland robbery incorporates battery, and there we were arguing battery can be committed by the actus reus of de minimis force, and so can then Maryland robbery. Now, this court rejected that argument, but it rejected that argument because there was specific case law saying that when Maryland battery attaches to Maryland robbery, the actus reus does change, right? It elevates from one requiring de minimis force to the quantum of force of injury or sufficient force to overcome victim resistance. And those actus reuses equal violent physical force, but that's not, but here, in stark contrast, there is no case law that says when the mens rea battery changes when it attaches to robbery. So this is like U.S. versus Red, Because in U.S. versus Red, the government was saying, making the same argument. They were saying when battery attaches to Maryland first-degree assault, it automatically transformed because of the firearm element. And the court said no. Why? Because they couldn't point to a single case which said when Maryland battery attaches to first-degree assault, that it takes on a unique meaning. So, and the
Does it
same
have
is
to,
true
does
here.
it have to, I mean, you know, certainly if there's a case that addressed that specifically and says it takes on a new meaning or doesn't, we wouldn't be here, right? We'd have absolute clarity. I think the question is whether the Maryland robbery cases, you know, Cooper and others that talk about like application of force, you know, whether that connotes intentional acts.
No, it doesn't, Your Honor, because even if you look to Red, it was the use of force, like, right? It was and so just the word use of force isn't sufficient. And it's good to look here. It's helpful to look at Borden. So in Borden, they said it wasn't the words use of force, it was use of force targeted against another, the use of force against the person of another. The Maryland cases don't say that. They just say that there must be Maryland battery plus larceny, and then rely on the
What's
battery.
application of force against another? What's the difference of that and use of
Because
force
against
against?
another
Let me-
person?
Let me finish,
Oh,
please.
sorry.
Yeah, I mean, the various cases talk about the application of force against another. That seems pretty close to what, you know, Borden's talking about.
I don't think so, Your Honor, because those cases don't say there has to be application of intentional force against another. There's two cases also, Your Honor, that I wanted to point the court to. So we have U.S. versus Wallace, right? This is, and I cited to another case, U.S. versus Weems, in my reply brief. And there, the court said that Maryland second-degree assault, which incorporates, which can be committed by a reckless battery, is a lesser included offense of Maryland robbery. And therefore, both of those cases, Wallace and Weems, make clear that both offenses can arise out of a reckless or intentional transaction. So in Weems, I'll start with that first. The court found that both second-degree assault, which can be committed by reckless battery, and robbery merge because they arose out of the same intentional or reckless act. That was a quote. That was in the verdict form there. It was a bench trial. And the offenses rose out of the intentional reckless act, and the court said they merged. So that tells us that Maryland robbery affirmatively can be committed by a reckless act. In Wallace, the court approvingly cited to jury instructions advising that the second-degree assault element of Maryland robbery can be committed by a reckless battery. And then the court found that the verdict was legally inconsistent when the jury acquitted the defendant of second-degree assault, which can be committed by a reckless battery, but convicted on robbery when both arose out of the same transaction. So, Your Honor, we have that case law. We also have the case law that Judge Walton astutely cited to, which says that the battery component of Maryland robbery does not have to be committed with the purpose of effectuating the larceny. So in other words, the battery and larceny do not have to be contemporaneous and coincide. So this means that the battery doesn't have to be planned to carry out the larceny. The larceny can be an afterthought. So if I recklessly run into somebody on the street, knock that person down, and thereafter decide to take the wallet of the downed victim, that's robbery.
Has
in
Maryland affirmed a conviction on facts like that or similar to that?
No, they have not, Your Honor, but that doesn't matter here. I think you're getting to the realistic probability.
It seems to me that's, and your point seems to be, if not rebutted, maybe at least put into serious question by the court's recent decision in Dixon, when we asked it to decide whether robbery could be committed by a threat of sodomy. And the court went through and explained the whole history of robbery and basically kept focusing on the fact that it has to be accomplished, the taking has to be accomplished by violence or the threat of violence. And it doesn't hit you head on, but it certainly suggests that there has to be some link so that, because if there's too big a gap, you will have an assault claim and a larceny claim. So they have to be, that gap has to be sufficiently closed so as to make it robbery. And of course, it's a specific intent crime, and mens rea would normally go through all the elements of the crime, but
So there's several things, Your Honor, that
I know.
I wanted to point out. So first
Take
of all,
whatever you want.
so first of all, Dixon, Your Honor, very different issue. The
It's a different issue, but they
issue
had
was
a
about
long
threatening
discussion.
property or accusations of sodomy. The second thing, Your Honor, you talked about
Except
violence.
My point from Dixon, and Dixon's very informative, they started with the common law and said, we have, this going back to the 1700s, that we have modified the common law in a lot of respects. And they then reiterated the formulation that they take to be Maryland robbery. And
Sure.
it seems to me a lot of those articulations say it has to be accomplished with force, it has to be done by force, or even with the use of force. They've used the word use sometimes. So these statements suggest that there's not such a gap that you are hypothesizing, and especially do we have cases that do that?
But, Your Honor, okay, so several things. First of all, if the larceny and the battery they don't have to be contemporaneous. It's the same general
They don't have to be
occurrence or same
contemporaneous, but they
episode.
have
But that means it can be reckless. But also, Your Honor, you also said that
But
it
they
can be
have to be
committed.
linked somewhat, I mean, they don't have to be contemporaneous, but they have to be linked so closely that the taking was accomplished by the force. And there has to be a specific intent for all of it.
Your Honor, no, there doesn't have to be a specific intent through all of it. I think if you look at every case that the government cites to on specific intent, it specifically says specific intent to steal. It doesn't say that the battery
No,
element
but
requires a
doesn't
specific
exclude
intent.
The force has to be specific intent too.
Your Honor, in U.S. versus Red, the government was making the same argument. They kept on saying that, look, Maryland first-degree assault is labeled a specific intent crime. And this court called out the government and said that was misleading because it kept on citing to a part of the statute that wasn't relevant to a different part of the statute. And it's the same thing happening here, Your Honor. They keep citing to a part of the statute that doesn't matter. I mean, the point is they don't have to be contemporaneous. When you combine it with the case law that says Maryland robbery includes, as a lesser included, second-degree assault, and that second-degree assault can be committed by reckless act,
Can I take
then
you
it
back to
follows.
the
Yes.
question I asked you earlier
Yeah.
about the lack of a Maryland decision affirming a conviction on facts similar to the hypothetical you pose or anything like it? And the reason I ask that, I recognize that it's not dispositive. You indicate correctly, I think, that it doesn't end the analysis, but it certainly is relevant, I think. And given the sort of dearth of case law, why wouldn't the prudent course of action for the court be to certify this question to the Maryland High Court?
Your Honor, that is definitely an option, but this court didn't do so in U.S. versus Red, where even in that case, there wasn't a single case, not one, where even in dicta, the court had said that, Maryland courts had said that first-degree assault can be committed by the reckless use of force. But what this court did is looked at the combined case law. And when it looked at the combined case law, it said there was a possibility that Maryland first-degree assault can be committed by the reckless
Is
use
a
of force.
possibility enough, or is it a?
There was a realistic probability. They
Right.
said that it was satisfied, even though there
But
wasn't a
the
single
difference,
case.
counsel, is, I mean, it may not be enough of a difference, that's your argument, but
Yeah.
the way the statute lays things out in the Red case, to me, presents your syllogistic argument more clearly than it does with what seems to be ambiguous case law at best here.
Well, Your Honor, I would disagree. I mean, that's not what the court said in Red, and the statute was unclear, so the court had to go to the case law. And so this is a very important quote. This was the conclusion in U.S. versus Red. Tying it all together, Maryland first-degree assault is simply second-degree assault plus a statutorily defined aggravating factor such as use of a firearm. And they're also important. They said use of a firearm, but still they said it could be committed recklessly. And then they say, and Maryland second-degree assault encompasses unintentional battery, which can be committed with a mens rea of recklessness. So if an individual commits a reckless battery with a firearm, he has committed first-degree assault. That's a conclusion. That's exactly what we're talking about here. They weren't looking at the statute. They were looking at the Maryland case law, interpreting the statute. Your Honor, the Maryland common law case law, the same case law that we're relying on here. There's one point also, I wanted to get back to Judge Niemeyer. You had a bunch of questions. I don't think I answered them all. But you know, one thing that the government keeps saying is that the battery is referred to as violence under Maryland robbery, and so that means there must be the intentional use of force. But no, Your Honor, because violence can be committed by injury or sufficient force overcoming resistance. And injury can be reckless. We know that because in Borden, the aggravated assault statute had a serious physical injury element, and the court still said it could be committed by the reckless use of force. And I urge the court to look at the Solicitor General's brief in U.S. versus Borden, because they cite to that and they say, look, Maryland robbery can be committed by injury. And under common law, injury in robbery statutes could be committed recklessly. So in Borden, the Solicitor General's warning the Supreme Court, if you find that the ACCA violent felony definition excludes reckless use of force, then that means Maryland robbery, along with a handful of other statutes, are going to qualify or aren't going to qualify as violent felony. And that's coming from the Solicitor General in Borden, Your Honor, and that's consistent with the case law that I described, Your Honor. So I think that red, Your Honor, is dispositive here, but actually we have even more than red, because we have the Stebany and Metheny line of cases which tell us that the battery doesn't have to be pre-planned. And then I don't know what the government's response is to these cases like Weems and Wallace, which say Maryland second-degree assault, which can be committed by a reckless battery, is a lesser included of Maryland robbery, and both offenses can arise out of the same act. In Wallace, Your Honor,
Mr. Patel, you're over your time.
Oh, I'm sorry. I got so involved.
Since you ended with the question about you don't know what the government's response is going to be to those cases, let's hear from the government.
Okay, thank you.
Mr. Mettinger?
May it please the court, Your Honors, my name is Jason Mettinger, and I'm here on behalf of the United States. Your Honors, we have to recognize Maryland robbery for what it is. It is a violent felony. It is a specific intent crime. Violence has to be directed at the person of another. Robbery is the quintessential violent felony. That's what the Supreme Court said in Stokeling. And this court in Johnson said that it meets the force clause of the ACCA. So we respectfully ask that this court would reconfirm that and find that Maryland robbery is a violent felony. I'd like to start with Maryland law, if I could. Maryland law has said time and time again that this is a specific intent crime.
But specific intent as to what? All of the elements or the intent to deprive?
So we submit, Your Honor, that it's as to all of the elements for a variety of reasons. But the best case that I'd cite for you is the Rayford versus State case. And that's a case where it says, quote, the force has to be directed at the victim. And that's an important point that we've been trying to figure out here, because Borden says as soon as it's directed at another individual, that's purposive, that is intentional, and that meets the violent felony test. The other case that I'd cite for you is Metheny, and I know that's a case both of us talk about. Metheny actually has language which I believe supports the government's position. Specifically, if you read it, with regard to the force element, it says you have to use force to, quote, neutralize the victim. And again, when you're neutralizing somebody, you're doing it in a purposive, intensive way. And this gets to Judge Niemeyer's colloquy with my colleague, the idea that there has to be some linkage, there has to be some connection. Because after all, if you read the definition of violence, definition of robbery, The taking is done by violence. In other words, that word by has to do some work. There has to be some linkage between the two. Otherwise, they'd be
So
separate.
in Mr. Patel's example of the motorist who gets into an accident and disables or incapacitates a victim and then at that moment decides to steal the victim's wallet, is that robbery under Maryland law?
So it's going to depend on the force application, Your Honor, and I think in our view, if you have intentional force that's directed at someone to effectuate the taking, it's going to be robbery.
But in my hypothetical, the force is the result of an accident. The victim is incapacitated, unconscious. The other driver then walks over to the victim and steals his wallet. Is that robbery under Maryland law?
Yeah, so, Your Honor, our view is that it is not. And it's not because, again, the force element requires a purposive, intentional use of force. The force has to be directed at the person. So in the reckless hypothetical, you're not directing your force at anyone in specific. You are tripping down the street, and then, you knock someone down.
So it sounds like your position is there's not something that explicitly says that you have to have specific intent on the battery portion of the crime, but the language about, the force directed at, the neutralization, the application of force, those things suggest that. Is that right?
Well, yes, and we would go a little further, not just suggest it, but confirm it in our view, like it has to be directed at. But I will also just say, Your Honor, the cases that we cite about this being a specific intent crime, many of the cases that we cite don't parse it up quite as finely as the defense would want you to. But again, under Aparicio Soraya, we have to respect and honor what Maryland courts say. And they just say categorically, this is a specific intent crime. I think when they say that, we should believe them.
What's your position about red and how it applies here?
So I actually agree with the position that I think you were staking out, which was red involved Maryland first-degree assault. That is a statutory crime. So the Maryland legislature codified it. They split up first degree, second degree, and then reckless endangerment. They put various mens rea with regard to the various modalities of first-degree assault. A completely different case. Maryland robbery is a common law crime, and that frankly should drive all the analysis here, because as a common law crime, that means a number of things. First of all, in McDaniel, this court said recklessness wasn't even a thing in common law, and it is messy and an inappropriate proposition to try to graft recklessness principles into what is a common law crime. So that's number one. Number two, in Rahafe, the Supreme Court said that in common law crimes, common law in general, we are going to have a singular mens rea that applies across all the actus reus elements. And that's why Rahafe came out the way it did. So that's why I agree with you, Judge Niemeyer, on what you had indicated, that yes, the mens rea should apply to all the elements. In a common law setting, that is
I think
true.
we've held that too, unless the legislative body indicates a bifurcated mens rea, that the mens rea of a particular crime applies to all elements of it.
That's correct. And so, that's our position. And so because, red was a statutory crime, it gets put over here. Because Maryland robbery is a common law crime, it goes in this other bucket. And so that's why we think that's an easy distinction for this court to make.
What about the Wallace and Weems cases that your colleague says suggest the other result?
So I appreciated that he cited those, but again, I don't think those speak to this question at all.
Tell me,
Again,
why is that?
It's again, sort of syllogistic reasoning, but what I'll say is, when you're talking about lesser included crimes, that just doesn't really tell you a whole lot. Like, in other words, reckless endangerment could be a lesser included of first-degree murder, but there's a lot of other steps you got to do to get up to first-degree murder. And here we're talking about what is the delta between an assault conviction and a robbery. There's a lot of elements that you have to do between there, and our view is one of the differences under Blockberger, one of the extra elements that you have to do is purposeful force. And so it's just clearly different. Yes, it might be a lesser included, but that just doesn't matter. The other thing that I wanted to touch on just briefly,
Before you get to that, and I recognize that the district court in this case in redacted, Judge Walton was applying the guidelines and not the term violent felony under the statute. But, I mean, that opinion, even if you disagree with it, seemed to be pretty thorough and thoughtful and raises a question at least as to what Maryland would do if faced with this question. So two questions. First, where did Judge Walton go off the rails, if you think he did? And second, why wouldn't that suggest that, given that, fairly thoughtful judge decided against you, that this is a matter properly to be presented and set before Maryland's High Court?
Great, so thank you, Chief Judge Diaz. I'll answer both of those in order. Number one, with regard to where we part company with Judge Walton on his analysis, it really involves this battery element, and I'm glad to have the opportunity to discuss it. He took the idea that the actus reus element, the force element, was battery, and then he went down the rabbit hole that the defense wants you to go down. But that's not the element. The element is violence, and it's different. And if it actually were battery, this case, this court's decision in Martin Johnson would have come out an entirely different way. So we're talking about battery now in terms of the mens rea element, okay? But the issue of battery and the quantum of force required for battery was at issue in Johnson. And so we all know that battery is something that can lie for mere de minimis force, that sudden snatching that we said is not going to be enough. This court rejected the idea that battery is an element. It's not. The word is violence, and it has to be an elevated violence because sudden snatching isn't enough. And so Johnson would have come out differently if they are right. The other thing that I'll say is if you read Maryland cases, it never says that battery is an element. Look at the Maryland pattern jury instructions. They don't say that you have to do battery. It's by force or threat of force. If you read all the cases, they say by violence. There's just that one Snowden versus State case where they said in parentheticals the idea of battery, and Judge Walton took that, unfortunately, and ran with it, in our view, at odds with what Maryland law says.
So make sure I understand that. You're rejecting the notion that battery is an element. Maybe this is a distinction without a difference. I thought the argument was that from the government was that, yes, battery, but it's battery committed with intentional force. Maybe that's just semantics, but you now seem to be saying battery's not even an issue, it's just, violent force. Is there anything about, I'm not sure I'm saying that right, but I'm just trying to figure out what you're arguing there.
No, appreciate it, Your Honor, and I think it is semantics, and this is why I'm using it the way I'm using it. When my colleague, Mr. Patel, uses battery, he means simple battery, de minimis force, reckless conduct. And when we're talking about robbery, we're talking about violence, a quantum of force that's appropriate for Johnson, and purposeful. So it is a little bit of semantics, but I do want to draw that distinction that we're not talking about simple
It's interesting that
battery.
the Maryland cases seem to use different words for the force. They use the word accomplished by force, or use of force, or just by force. And I don't know if they're all intended to mean the same thing. I do know that I think it was Justice Kagan that did the analysis of what the word use means. It's purposeful, or Stokely. I know one of those opinions analyzed the verb, which they found quite important. When you direct it at somebody, you accomplish it by something. It links it, and it directs it, and makes it purposeful, I think. And it depends on what particular formulation you get from the Maryland cases. But I have noticed that they've used different verbs, so to speak.
So they certainly have at times, Your Honor, but I would agree just generally that all of the cases, again, I think we can go back to the idea that this is common law. This isn't something new. And we know what common law battery is. In Stokely, the Supreme Court said common law battery is the quintessential violent felony. And I think that should really inform our analysis here. Chief Judge Diaz, I did want to get back to the second part of your question, which was, should we certify this to the Maryland Supreme Court now? We respectfully submit that we don't have to. We think this is clear. But certainly if this court, did that, we respectfully submit we know how it would come out. And I think we know how it would come out because this gets to your other line of questions with this realistic probability test. In other words, Maryland has, more than 200 years of jurisprudence. And I'm not aware of a single case which splices up the mens rea element the way the defense is professing that it does.
So, but that's an interesting argument, and we've talked about that in cases, and, but what's the relevance of that after Taylor?
So I submit, Your Honor, that this court does apply the realistic probability test to this line of cases. So it did it in Ogle. Also, the Supreme Court in Moncrief has said what it said.
But Taylor tells us if it's, and I think this is how I looked at it, Taylor tells us if the elements are clear that that force is not required, whether there's cases, not only is not determinative, I read it as almost to be irrelevant. But the first part of that, what I said, I think is important. There it was more clear, arguably more clear, that the elements did not require force, whereas here that's the kind of fundamental question. Is that how does that make sense in terms of, how Taylor applies here?
So it makes sense, Your Honor, but I will say that there is a little bit of fluctuation in terms of some courts are looking to this reasonable probability test, and some are saying, well, it's not required here. And I just know this court in Ogle did it. There's also two other cases that I think are important to mention here, both Doctor and Burns-Johnson. Those are cases from 2016 and 2017 in this court. And there was this question of, can you commit an accidental robbery? In other words, this idea of negligently tripping down the street and then getting a robbery. Granted, these are pre-Borden, I understand that. But this court was looking at the realistic probability test in both of those cases and said, there's no way, we see nothing in North Carolina law or South Carolina law that would even remotely suggest that this is going to lie for these kind of robberies. And so I've just seen time and time again this court apply the realistic probability test. And so, I think it's an appropriate yardstick, and I think it should speak some volumes here. Your Honors, I did want to briefly touch on Stokeling, because I think a little bit of history can help shed a little bit of light here. So we're construing the ACCA, and Stokeling ran us through the history of it. And if you look at the first iteration of this in 1984, robbery was one of the crimes that Congress enumerated that said this shall be an ACCA predicate. And it defined robbery in ways that is essentially indistinguishable from Maryland common law robbery. Okay, so then flash forward to 1986 when they expanded the ACCA to what we have today. And so our argument is, if you look at the history of it, clearly this is something that must be included. In other words, Congress meant for typical common law robbery, which Maryland is, to be within the field of what the ACCA covers. And so I think it'd be surprising to say that it is somehow now out, when it was the first thing that was there, and there's no reason to suggest that it should be out. Your Honors, I did want to mention just a couple other brief secondary points, if I could. Maryland robbery is keyed to federal bank robbery. So if you look at 18 U.S.C. 2113, they have the same sort of by force or threat of force language. And the Maryland cases talk about how we want to construe ourselves in pari materia with federal bank robbery. So I do think to accept the defense argument would have some inappropriate second and third order ramifications. There's just a lot of statutes that have by force or threat of force. And, Supreme Court has been very clear, we shouldn't interpret statutes in a way that are self-defeating. And I think to accept the defendant's premise here would do just that. So I'll just end where I started unless there's any other questions, just to say, we think this is the quintessential violent felony, and as such, we respectfully ask that this court so find.
Thank you very much, Mr. Mettinger. Mr. Patel?
Thank you, Your Honor. Just a couple of points. So, going back to your question, Judge Guattlebaum, about the application of force or the use of force, again, red is very central here because there, the court was looking at the Maryland second-degree assault statute, which included second-degree assault definition, which included battery, and specifically said it requires unlawful application of force to the person of another. Yet this court still found that it can be committed with the reckless use of force. And taking us back to Borden, so in Borden, it wasn't just the word use of force, right, that the court said required intentional use. It's use of force targeted against the person of another. And they said those two together meant there had to be intentional use of force, because before that, we had Voisin, and the Supreme Court's decision in Voisin, there was that language, use of force. But the court said that wasn't sufficient, because in Voisin, when the court was interpreting the 922G9 force clause statute, it said it can be committed recklessly. So the words use of force are not dispositive, are not relevant here, Your Honor, because, again, because the Borden made that clear. It's not just use of force or application of force.
Except Borden went a little broader. I mean, in the discussion in Borden, against the person was necessary in order to bring it out of the property, and the idea it's against the person, the threat of a person. But the court did cite Voisin and said means the volitional or active employment of force.
Sure.
And then it says, as just explained, this is now from Borden, use of force denotes volitional conduct. So that's not, it's not necessary to have the object that's directed against the person, against the person, the fact, of course, the court later pointed out that against is very helpful.
Yes.
But the use, it acknowledged was the volitional aspect, and of course, then Justice Thomas joined to make the majority.
But I think volitional isn't enough, because, of course, in every offense, you're knowingly doing the act, but that's not enough. It's whether you're knowingly doing the act with the purpose of creating injury, right? Like, so just knowingly do it. So if I'm running, yes, I know I'm running, and I'm intentionally running, but Borden requires more than that. It requires harm directed against another. So that's different. Also,
Didn't Stokeling talk about use carries purpose? That when you use it, of course, it means it's purposeful, it can't be accidental?
No, Your Honor, I don't think Stokeling says that. Stokeling was very different case. It wasn't about the mental state. It was about the actus reus. I don't think it says that at all.
Maybe it's locale or something.
But, Your Honor, also I wanted to point out, Judge Quattlebaum, you asked about the
I'm
realistic.
reading from locale, I got the wrong one. It said, the most common employment of the word use connotes the intentional availment of force. That was
Right.
from locale. So,
Right.
I mean, that's the
But-
idea.
but
That's the thought that's
subsequently-
picked up.
Subsequently, Voisin still said use of force wasn't sufficient, right? Like that could encompass reckless use of force. So I think the against the person language was very critical to the Borden decision, which none of the Maryland cases use,
Maryland
right?
cases, I thought, used stronger words than that. They use words like accomplished, directed, they use words like, they have different formulations. They use accomplished by force, or when they recite the common law.
And Your Honor, all of that was also available in U.S. versus Red, yet this court,
Yeah, but that's a
interpreting
different
the same.
crime. That's a different crime.
Yeah, but they were interpreting the battery element and using they said unlawful application of force. And there was also a firearm element there and use of a
Telling
firearm.
that you need to use the battery cases in order to get to robbery, and robbery is not battery. Robbery has its own defined term, and it seems to me the best help we can get is to look at the robbery cases.
So Your Honor, again, I would really encourage the court to look at Wallace versus State, because there again, the court said second-degree assault is the lesser included,
I know, but
and
that says
then
nothing about the first. A lesser included means the first has sufficient elements to cover the second.
But Your Honor,
But it doesn't mean the second dictates what the first is.
Well, Your Honor, I think importantly, though, in that case, the court approved a jury instruction on Maryland second-degree assault and specifically said, in the context of a robbery case, that the contact must be the result of an intentional or reckless act. And so it's not just that it's a lesser included. They specifically instructed on second-degree assault and then said, because there was an acquittal on second-degree assault, there can't be, it was legally inconsistent with the robbery offense. And in Weems, Your Honor, again, I think that these are really, really important cases. The verdict form reflected that the acts, the robbery and the second-degree assault, were the result of an intentional or reckless act. And the court said they had to merge. So they're talking specifically about intentional or reckless in those cases.
I think your syllogism is an interesting syllogism, and there's a lot of logic about it. But your entire argument in your brief and today is analyzing either assault or battery as crimes. And in every instance, you have to start taking a question of whether that is meaningful to robbery. When we have case after case on robbery, and we don't have the attributes that you attribute to assault or battery.
Your Honor, it's the same thing here. There is not a single, there's not a single case, though. The government was making the same argument on Maryland first-degree assault. There wasn't a case in Maryland first-degree assault which said when battery attaches to Maryland first-degree assault that the mens rea changes, and it's the same thing here. We can look at every robbery case. Not one of them says that it changes, and it's upon them, Your Honor, at this
It's just
point.
the opposite. They don't use the word battery when they describe the elements. They have the one case that has its parenthetical, but it has been later, it was...
But Your Honor, it's not this, it's Snowden. It's a Supreme Court case from Maryland that says that battery is an element, and then you have Fetro versus State, another case which also says the same, Your Honor. So it's absolutely clear. And then in this Wallace case, in this Weems case, battery is a very important component. It's a component of Maryland robbery. And just because...
Is it statutory battery or common?
No, it's common law battery. It's all common law. And it's that common law battery that was incorporated into the definition in first-degree assault also. We're talking about the same type of battery, Your Honor. And when you have that syllogism, when you have the logic that tells us that Maryland robbery incorporates reckless battery, then there has to be something else telling us that it doesn't. And we don't have that here, just like we didn't have in red under first-degree assault. Your Honor, Proctor is also another case I would urge the court to look at, because the same thing was going on there. That was about the actus reus, but the government was arguing when battery attached to the higher offense of assault with intent to prevent lawful apprehension, that there also it changed. And the court said, no, you have to come up with a case that says that it's different once it's elevated, and they haven't done that here, and that wasn't done in Proctor, and that wasn't done in red. There's one more thing I can talk about, the realistic probability
Well over your time
test.
on rebuttal.
Okay.
Thank you very much.
Thank you, Your Honor.
You know, by stopping, you avoid a ticket for going through the red light.
We thank both counsel for their excellent arguments. We'll come down and greet you and take a brief recess before moving on to our final two cases.
This honorable court will take a brief recess.
Our third case is 23-1911, Shelby Roberts versus Carter Young, Inc. Mr. Roberts?
And I believe counsel on the other side is not completely back
Oh.
from.
Well, that's unfortunate.
All right, thank you, Your Honor. May it please the court. This is a Fair Credit Reporting Act case, which the district court dismissed on a Rule 12b-6 motion. We contend that this was erroneous and that the district court adopted a view of the Fair Credit Reporting Act that does not comport with this court's holdings, or really with the holdings of most courts. The Fair Credit Reporting Act is obviously a consumer protection statute aimed at protecting consumers from false information. Section 1681 S2B1, which is the critical statute or provision in this case, authorizes or provides a mechanism by which consumers can contest information they contend that's false in their credit report and can actually get a correction of that. So essentially, a furnisher, upon being notified by a consumer reporting agency a furnisher, upon being notified by the CRA that the consumer has disputed some element of their credit report, is under an obligation to conduct a reasonable investigation of the dispute and to take appropriate action. And the statute specifically defines what that appropriate action is. Originally, it did not go to furnishers, but in 1996 and then again in 2003.
But the investigation, counsel, is to accuracy and completeness, not any dispute, right?
It has to be to the accuracy of the information that is disputed in the file. So in this case,
You agreed that the agency does not have to investigate in other words, the facts of the dispute and make resolutions. In other words, they don't have to go start questioning witnesses and get expert witnesses and go to the scene. It seems to me it's an existential question whether the dispute is a real dispute, in other words, or they got the wrong name, or whether it's manufactured, or whether it's been settled. But an important aspect would be disclose that it is in fact disputed. But in this case, they checked and they found that she was the lessee, she left the apartment, she was actually billed for damages, that the bills remained unpaid, and that it's disputed. And they did report that it was disputed, right?
they reported that it was disputed, but they
Okay,
did
now,
not.
all those facts are accurate. Now, what you're asking is that they go into the aspects of the dispute and make a judgment call as to whether the claimant or the respondent is more correct. She says this was retaliatory and fraudulent. Well, fraudulent says what didn't exist. Well, it did exist. It's a real claim, and they checked that out and found it was a real claim. It was retaliatory. That goes to her defense. They don't have to resolve whether it's retaliatory or not, or whether it's good faith, or whether the damage was sufficient. Seems to me you would be imposing a mini trial investigation. You get experts, and then she'd dispute whether they came out with the right result, and you have no appeal process. I'm not sure what investigation, what did you want them to do besides verify that the complaint was there and it was disputed?
Well, I wanted them to, I don't believe this court's decisions exempt them from investigating the merits of the dispute.
Well, we have two cases, as I understand. One says we need a reasonable investigation, and the other is we said we have to look at the files and the documents in the file to make sure that the report was accurate. Isn't that what it says? Sanders or whatever it was?
Well, I mean, I believe the Johnson decision was a seminal decision, the 2004, and in that one, you know, the issue had to do with whether the consumer was responsible, legally responsible for a particular credit card file.
How can they make that determination?
or you have to go in and conduct an investigation. There's nothing in the statute I see that
I mean,
exempts.
who's legally responsible? All we
No-
have to report is that it's disputed. I mean,
I don't believe Saunders said that that's all you have to do. Saunders was the
well,
decision that.
take me on. Tell me what you wanted them to do. You wanted
Well, I
them
wanted
to
them-
question witnesses?
I wanted them to talk to the creditor, in this case, the landlord, and actually investigate the facts that we were alleging, which was that the charge, a $500 plus charge for a new stove
Well,
was.
that goes to the dispute. And number one, your allegation is basically that it only needed a handle. We didn't hear the other side's claim. Maybe there was other damage, number one. Number two, that was $500 of a $1,200 bill or $1,300
Well,
bill.
the only thing
And
that's.
the other for damages, and the lease requires that. Now, she disputes that there's damage, but the
The
fact
lease
is-
isn't even in evidence. There's no, I mean, this should not have been dismissed on a motion to dismiss. This was they didn't dispute that the lease made the landlord responsible for repairing the handle. There's no evidence in the case that they had a different view of the law
All
or
right,
of the
so let's
lease.
go, the investigator, the credit company goes and asks questions and concludes that the claimant has a legitimate claim and should win. And then, and puts that in there. What would her response be then?
And puts what in there?
Puts it in the report. We investigated this, and based on our investigation and questioning the witnesses, we think it's a legitimate claim.
Well, they didn't do that, though.
I
They
said
didn't,
hypothetically, if they put that in, what's your client's response?
Well, that was false, that they
was
did not
false.
have sufficient information in their possession to verify the debt. The
My
statute,
hypothetical is they asked the questions, and they were told about some wall damage. They were told about the fact that there was a dent in the front door of the oven in addition to the handle, and that the replacement was, fixing it cost more than its value. I mean, this is the type of stuff you want the credit company to get involved in, and then she's going to dispute it even more.
it's not the credit company, though. It's the furnisher of that
The furnisher,
information.
okay.
And the furnisher has an obligation to investigate the merits of the dispute. I don't think this case, Saunders did not suggest, in Saunders, the dispute was not an inaccuracy in the information, but a misleading or an omission that it didn't, and so that was a completely different case. This court has not held, I don't believe Johnson or Guthrie or any of those decisions suggest. Guthrie was a case involving a bankruptcy plan, and the creditor had to go in there, or the furnisher had to go in there and investigate whether that was a legitimate, or whether the disputed information was actually correct. I don't know how you can investigate a charge or a dispute without getting into the merits of that dispute. And then the issue.
What you can do is you do an existential investigation to avoid the notion that there's a claim. In other words, the claim could be related to another person with a similar name, or the claim could have been settled, or the claim could have, in other words, something that it should not be attributable, the claim should not be attributable to your client. But in this case, the claim was made. The invoice was sent, and she disputed it, and they reported all those elements. Now, you're asking the Carter to go in and go out and find witnesses, so they report what they find, and your client then disputes it. And then you have the same type of litigation. I mean, it seems to me the question is whether there's a disputed claim is a fair statement. There is a disputed claim.
But that is not all that the statute requires. It didn't
The statute uses the word investigate, right?
investigate, reasonably investigate
It
to
doesn't say
determine.
reasonably, does it?
But no, but this court's Johnson decision clearly
said
says
reasonably.
reasonably.
All right.
And which requires a searching inquiry, and not a superficial inquiry. There was much that they could have investigated. We believe, and we allege that they had, in essence, had been told by the clients that there was nothing else. They didn't purchase a new stove, they didn't
Counsel,
replace it. Yes.
Go
Yes.
ahead, finish your answer. I'm
Well,
sorry.
they could have charged her $50,000 for it. There's not, I mean, this means they can fabricate a charge out of thin air with nothing in the lease that supports it. The lease and state law both require GS 42-42A4 specifically requires the landlord to correct or fix and repair items such as appliances such as this. So this would have just opens the door to any kind of fictitious charge.
So, looking, kind of to follow up on the dialogue y'all are having, in the complaint, it seems like you, on the one hand, use some language that's kind of tortious and legal, like Judge Niemeyer was talking about, retaliatory, fraudulent, and things like that. And it seems to me those sort of legal concepts are, perhaps beyond what would be expected of, of a furnisher, because that's almost conducting a mini trial. But let me finish. I'm trying to see if there's anything in here beyond that. But, fairly reading your complaint, you do say that you were charged for replacing a stove and the stove wasn't replaced. That seems like it's a yes-no thing. Was it replaced? Correct. Also, you say there's some other charges that were non-existent. Those seems like yes-no things. Those seem to me different than whether damage is, whether conduct was tortious or whether damage was, normal maintenance and things like that. Seems to me, maybe, whether damage is, caused by someone or is normal wear and tear might be beyond what the statute's talking about with accuracy and completeness. Certainly the tortious stuff that is alleged seems like it's beyond accuracy and completeness. But is there something to this notion that, quite frankly, it seems like, that your colleagues are suggesting, that accuracy means, objectively and readily verifiable. And whether a stove was replaced seems like it's, objectively verifiable.
My time's out, but if I may answer that question. Yes, the term fraudulent just was used not as a state law fraud claim, but as a claim that it was fictitious. It was created out of thin air. We're not asking them to resolve some kind of legal claim. Fraud simply means that it's false, it's inaccurate, at least as the way we were trying to use the term. Retaliatory was simply explaining why they did what they did. Why would a landlord fabricate a debt like that? It begs that question, and we offered an explanation for why they would do that, not asking them to investigate whether it was truly was retaliatory. There's no retaliation defense to a debt. If the debt was valid, if the debt was correct, the fact that it may have been motivated by retaliation would not be a legal defense to it. So that just offered context and explained why they might do what they did.
But
so yes.
But if you said, for example, if someone said, maybe I was billed, maybe I didn't pay, but I was fraudulently induced into this contract, that's not accuracy and completeness. Would you agree with that?
If a fraudulent inducement claim, yes, I would agree that that's not something that they would be required to. And there's nothing in this complaint that suggests it.
We got to decide not just your case, but other cases.
Yes,
so I'm just trying to make sure where you're going with your argument.
Well, we don't dispute that if something's accurate and that there might be certain, like, legal claims, like they cited in a supplemental letter, the 11th Circuit's Holiday Inn case, where there were competing court decisions about the impact of these timeshare agreements. And those where the court held that where you can't really, how can a furnisher or a creditor or a consumer reporting agency decide between those? There's nothing like this. They don't offer any contrary view of the law or of the lease. As I say, the lease isn't even in the evidence, but we pled that it made the furnisher or the landlord responsible for that. So, but here's what they could have investigated, if I may, is they could have investigated. Ansley was their client. This is not somebody that they had to go out and seek out. They had direct access to it. They could have asked, for one thing, they could have asked for an invoice, a third-party invoice showing that they did replace the stove. that would have arguably verified the charge for it. But as I understand the case law, the Hinkle decision out of the 11th Circuit, I think, is instructive, is that the question, when a furnisher re-verifies, which is what they did, when they re-verify a debt or disputed information, the question becomes whether they had in their possession sufficient documentation or evidence to support it. At this stage, we don't know what they have. There's no, in our view, this was an entirely premature dismissal of the case, but in any event, we don't believe that they have anything that would support the charge for a $500 plus charge. With respect to the miscellaneous damages, they could have simply requested a statement from the maintenance department detailing the labor and material cost, and they didn't do any of that. So I think that there is much that they could have investigated, and I do not believe that the district court was correct that you can simply, this is not just a transcription error. The Second Circuit in CESA, you know,
All right,
specifically.
Mr. Roberts, you're way over your time.
All right, thank you.
Thank you. Ms. Bloom?
May it please the court, Karen Bloom on behalf of the Consumer Financial Protection Bureau. In the last year alone, the Bureau received over 1 million complaints related to credit and consumer reporting. Among the most common issues identified were incorrect information on a report and problems with companies' investigations. Each consumer who faces detrimental information on a report can face dramatic consequences, including but not limited to their finances, their employment, and their housing. Congress recognized the importance of fair and accurate credit reporting, including the importance of excluding false information from consumers' credit reports and preventing the reporting of unverifiable information.
Ms. Bloom, can you respond to Judge Niemeyer's hypothetical of a furnisher who conducts an investigation, prepares a report of some kind and submits that information to the debtor, and the debtor continues to dispute the information, and you sort of have this endless cycle of dispute followed by investigation? At what point does the furnisher's obligation end?
So I think this court has been clear that the investigation must be reasonable. And again, the reasonableness is a fact-specific determination. It depends on what information was provided to the consumer reporting agency. To the extent there's only minimal information, there may be a lesser burden on what that reasonable investigation may entail. It depends on who the furnisher is, whether it's the creditor themselves or somebody else. There are all sorts of factors that could play into this. And so the reasonableness is really key here. And this court appropriately for the last 20 years has held that that's what should be relevant here. And
Well,
so
let me ask you, what's your position on a situation, and we don't need to relate it to this case in particular, a situation where a landlord sends a bill for damages for an apartment, $2,500 bill for repainting and damaged plaster and all kinds of things, and the defendant disputes it and says it's for normal wear and tear, and says, I don't owe it, and it's reported. Now the furnisher is got an objection and goes back to the landlord and said, did you make this claim? I said, yes. And you made this claim for damages? Yes. Has the damages been paid? No. Is the dispute still open? No. Is the claim disputed? Yes. And that's what they report. Now, that's one approach, which seems to make a lot of sense, is to eliminate fraudulent claims, ones that don't exist, ones that are settled, ones that got the wrong person, this type of thing. The second suggestion is the company goes in and investigates, and the landlord gives them photographs of what was done, the damage, and gives them a breakdown of the billing. So now the credit furnisher, the information furnisher, puts in the report, there is a claim We have verified that there were damages there. They were excessive damages, and we believe that the charges were fair. Okay, puts that in the report. What's the creditor, has the creditor been benefited in that? Or what's the creditor's position? In other words, I'm worried about us creating a mini trial under these regulations where the furnisher has to conduct a proceeding as a prosecutor and investigator. Instead of just reporting the fact that a claim has been made. I've gone back to the landlord. The landlord says it is a claim. We did make that claim against this person, and we believe the person's owing it. It seems to me to have them go start questioning witnesses, taking pictures, investigating, getting experts, you get into this internal battle, and we're going to have mini trials in the process. Is that what was intended?
Respectfully, I don't think so.
And of course, the person who loses on that report is going to object.
I do think the reasonableness inquiry does get at that, right? So it doesn't necessarily always mean bringing witnesses, but it does mean not just taking the fact that there was a bill as the end of the story, because we know.
A disputed bill. In other words, a bill was sent, what it was sent for, and the question in my hypothetical is they sent it for damages by the lessee and said, yes, we sent that bill and it remains unpaid, but we tell you she has disputed it. Now, that seems to me, she can put anything she wants in, but it's the fact that it's disputed all of a sudden creates a situation where does the furnisher have to give details of the dispute?
So respectfully, I do think what the furnisher has to do is reasonably investigate. And so,
The reasonably doesn't help us. I mean,
well, I think it,
we use the word reasonably in our earlier opinion, but reasonable, we assume everything's reasonable. You know, the Sherman Antitrust Act said any combination, contract, or conspiracy and restraint of trade is illegal. And the Supreme Court says, well, that really means reasonable. I mean, we put reasonable everywhere, and that's okay. I agree with that. But my question still is, when we're investigating that, is what is the line that you believe should be followed? In other words, how far should the furnisher get into the merits of the dispute?
I'm conscious of the time. Can I
Please.
take the time? So I think it's important to recognize what Congress was trying to do here. Congress was looking at tons of people facing inaccurate reporting and investigations that weren't sufficient. And even now, right, we still face millions of consumers a year who are facing inaccurate reporting and struggle to get the inaccuracies removed from their reports.
That doesn't
And
help me on my question.
So sometimes it may just be looking at whether there's been a judgment that's not being reflected in the situation. And so we know there are lots of cases where there, for example, has been a discharge and somebody is still being reported as owing a
Yeah,
debt.
that's an
And so-
inaccurate deal. But
so-
here, my hypothetical is where, not this case, but similar, where the lessee is sent a bill for $2,500 and the itemized damages, and the furnisher checks and said, yes, there is indeed a claim. It's not been discharged, but it's disputed. And that's what's reported. Now, your suggestion, I don't know if it is your suggestion, that's what I'm asking, is to what extent does the furnisher have to get in and report the accuracy of the claims and defenses?
The furnisher is not, their obligation is not to adjudicate the debt, right? That's not what's going on here. They just have to investigate and determine whether they have a sufficient basis to believe that the debt is owed. And so if they reasonably believe they have a sufficient basis, that's the inquiry that on review a court would be looking
So the
at.
landlord says, they call up the landlord, and the landlord says, we had a lease with this lady, we had a deposit, we have a claim for damages that's more than normal wear and tear, and we sent her a bill. And she has disputed it because she doesn't believe, she believes it's normal wear and tear. That's the information. Do they have to go further?
I think it's a fact-specific
No,
question.
on my case.
That's what we're trying to figure
So,
out, so that
I
we
think I
got,
can help you.
yeah, we got a question about whether, it's one thing whether they did the painting or they bought a new stove. That's a yes, no, maybe thing. We could debate that, but whether the damage is normal wear and tear versus whether it's not, I think goes to the heart of what we're trying to figure out here.
And I think that exactly gets at what the difference is between having the inquiry be about a reasonable investigation and determining on the front end whether or not a dispute is readily and objectively verifiable. What the appellees here are arguing is that there should be a determination on the front end before any development about whether this is a dispute that is about accuracy or not. But the cases that standard comes from were after a whole development of a record, and so.
Let me interrupt you. I understand your position about a front-end kind of screen, and I'm not trying to be rude to cut you off, but assume you get the notice, you have a duty to investigate, and the furnisher learns that the landlord says there was damage, the tenant says, I didn't do it, so there's a dispute about whether it was normal wear and tear or not. Does the duty to investigate include resolving whether the damage was normal wear and tear or not?
It does not necessarily involve resolving it. It does involve doing a reasonable investigation so that the furnisher has a sufficient basis to conclude that the debt is owed.
So what does that mean?
So, for example, if they just asked, did you bill this, without, in the hypothetical, asking, what were the damages, that may be unreasonable.
So just saying there's a bill might not be enough, but saying, were there actual damages? And if they say yeah, is that reasonable?
And what was done, right? So in this case, for example.
You then concluded by, they had to affirm that the debt was owed. And to me, she says she didn't owe the debt, and the landlord says she did owe the debt. Now, are you asking the furnisher to resolve whether the debt was owed? And you said yes, but I don't understand how you get to that result.
So I think there are a few things going on here. There's the question of what the furnisher has to do under the statute, and then there's how does a case proceed, right? We're at the motion to dismiss case, so really stage. So all that's before the court, right, has this plaintiff plausibly pled a violation of the statute?
I know you don't want to answer my question. I'll ask it once more. Does the statutory duty require the furnisher to get involved in giving an opinion about the validity of the debt in terms of merits?
If furnishers are furnishing information about a debt, they have to have a sufficient basis to believe that debt is owed.
Well, they call up the landlord, and the landlord said, yes, there was damage caused beyond wear and tear, and we sent a bill. Is that enough?
Again, it depends on whether there's factual information.
Is that enough as a matter of law?
It's a fact-specific inquiry.
What other fact do you want to know?
So, for example, whereas in this case, there was an
No, not this
allegation
case,
that
my hypothetical.
if a consumer alleges specifically why the damages were not what they were charged to be,
Because it's
then that would,
normal wear and tear.
well, then I think that may involve more of an inquiry. And I think Congress thought so too, because Congress contemplated an assessment after the investigation of whether the reported information could be verified, and said if it couldn't be verified after an investigation, then it needed to be changed and reported to the Consumer Reporting Agency that it needed to be modified. And so because Congress put that verification inquiry after the investigation, it's inappropriate to be doing it on the front end under this rubric of whether or not the dispute involves something that is objectively and readily verifiable.
All right, thank you, Ms. Bloom. Mr. Ost?
My name is Jonathan Ost. I'm representing the appellee Carter Young. Mr. Roberts alleges that Carter Young, a data furnisher, violated the Fair Credit Reporting Act when it failed to conduct a reasonable investigation in response to her dispute to a CRA. The text of the FCRA limits a data furnisher's obligation to conduct a reasonable investigation to only one of two things: completeness or accuracy. Ms. Roberts and the CFPB incorrectly argue there's no such limitation. This appeal only relates to the first limitation, accuracy. Accuracy under the FCRA is objective, meaning it is something that is objectively and readily verifiable. If a consumer's dispute does not challenge information that is objectively and readily verifiable, then the FCRA does not apply.
But the question, I think, on that issue, I mean, there's a timing issue here of whether you have to investigate or not. And I understand your position now to say that the furnisher, upon receiving notice of a dispute about the accuracy and completeness, then gets to decide whether or not it really is about accuracy and completeness. Am I understanding you correctly?
Correct, Your Honor.
Okay. Yeah, I mean, the trouble, I mean, I'm not sure how that the statute supports that. I mean, I think it makes sense to me that the ultimate investigation is about accuracy and completeness and not a bunch of things that fall outside that, and we can talk about that. But, you know, if you look at the notice, if you go to the section in the FCRA, I think I got it right.
Yes, Your Honor.
That describes the notice, it's talking about, in an indirect claim like this, there is a notice to the credit reporting agency about accuracy and completeness. And that credit reporting agency does some screening, including for whether it's frivolous or not. But if they say it is and they send it on to the furnisher, you know, then as I read the statute, they have to do an investigation. I know it says in the lead-in paragraph, it's about accuracy and investigation, and you're trying to say, well, we get to decide whether it's about accuracy and investigation. I think that's really just describing the type of notice. I don't think that's giving the furnisher the ability to say, hey, no, this isn't the sort of thing I have to do an investigation about.
Well, I think that argument completely reads the words accuracy and completeness out of the FCRA.
No, it doesn't. It just says that determination is made by the CRA who gets the report, and when it repeats it, it's just describing what happened in the earlier section.
Well, the 1681I, I believe, is the section referring to about the CRA's duty. When you read both sections of the statute, they have the exact same language. And I disagree that I think that it is an important distinction that in S2B they include completeness or accuracy. They did that for a reason. They didn't just use it as a reference point back to 1681I. Here's the reason why. It's because also in S2B, there's the time limitation. And in S2B, they don't just say 30 days like they would. They refer back to the statute. And so in one section of S2B, they don't include the words. But specifically in S2B1, they do specifically include the words accuracy and completeness.
What if I assume, and this is not a decision because I appreciate that argument, we'll all think about it hard, but assume hypothetically that you do not get the ability to decide on the front end whether you do an investigation or not. Mm-hmm. But you must do an investigation if you get a notice from the credit reporting agency about the accuracy and completeness, and you got to go do an investigation. Is it your position, it seems like your position would naturally follow that what our investigation should be is about things that are objectively and readily verifiable?
Correct, Your Honor.
Okay, and let's kind of try to figure out what that means in this case. As I read the plaintiff's complaint, they allege, and I asked your colleague about this, a number of things about fraudulent and retaliatory and things like that, and ordinary wear and tear. And I understand that getting into that arguably might make a furnisher conduct a mini trial, and I think that's not what's required. But I think at a 12B stage, it's fair to say that the plaintiffs have said that they were charged, that the landlord said, I'm charging you for replacing a stove, and that the landlord never replaced the stove. Isn't it objectively and readily available as to whether the landlord replaced the stove or not?
Well, I think to answer your question, there's a distinction between what Ms. Roberts told the CRAs was the basis of her dispute as opposed to other facts in the complaint. So, and the reason I say that is there's 3 specific allegations in the complaint of what she told the CRAs. It's paragraph 30, which is Joint Appendix 9,
Yeah.
paragraph 35, Joint Appendix 10, and 63, which is Joint Appendix 14. In those 3 allegations, she specifically says retaliation and fraud. She does not include any factual assertions as to this is why I don't owe the debt. Her entire basis of the disputes to the CRAs was retaliation and fraud.
Well, so, I'm sorry.
No, go ahead.
So, but I'd like you to answer Judge Quattlebaum's hypothetical. If you think it's hypothetical, the plaintiff thinks otherwise. But if in fact the allegation was, I've been charged for a stove that was never installed or replaced, is it your position that that doesn't need to be investigated?
Part of the point is that
That's a simple.
that
that's a
fact can
simple-
be
hold-
objectively and
hold
readily
on,
verifiable.
hold on.
Correct.
Okay, yeah. So that is, you can see that.
Correct.
Okay.
But-
So you have a duty to investigate that.
Well, that is, if that is the basis for the dispute. There's no allegation in this complaint that I don't owe this debt, or no allegation that they told the CRA, I don't owe this debt.
But the complaint says, I mean, you may, and we're at 12B6, we're governed by the rules of civil procedure, and we have to accept allegations as true and reasonable inferences from them. And I think there's allegations in the complaint that get into legal stuff that, would go beyond what's objective or not. But I think it's fair to read the complaint to say, landlord says I replaced the stove, I'm charging you for it, but they never did that. And that seems like even under your test, that would be objective and readily verifiable. All you gotta do is say, did you replace the stove?
Wait, here's the other facts that are in the complaint when you look at all of them.
So I got it, but let's assume they had just said that. Let's assume the complaint says, I got charged, the landlord charged me for a stove. The landlord said it replaced the stove after I left. It's charging me for it, and the landlord has never replaced the stove. That's it. That's the 4 corners of the complaint. And is that something the furnisher has to investigate and say, landlord, did you get a new stove?
I agree with, yes, that would be something that would be objectively readily verifiable. There's going to be the answer to that question. But the issue we have here, the motion to dismiss, when you look at the other allegations in the complaint, I want to make something clear, that when you read the complaint, there's an allegation that there was damage to the stove. There's allegations that could have been repaired. Ms. Roberts in her brief keeps arguing it was repaired. There's no allegation that the stove was ever repaired. You also have a subjective nature where there's a dispute between Ms. Roberts and Ansley,
Right.
where Ansley says it was forcibly pulled, and Ms. Roberts disputes that. And so the one fact that is objectively readily verifiable is whether or not the stove was replaced. A lot of the other stuff in the complaint is all
I thought the
subjective.
complaint said it turned out later that the stove was never replaced, but at the point of the complaint, this is a timing issue, at the point of the complaint, there was no complaint made that the stove wasn't part of the claim, and the furnisher was never put on notice to investigate the stove.
I think, Your Honor, I think it's important that you don't have to investigate things you know are a dispute. And so.
And the report, whether the report was accurate. Now, I don't know, is the record actually have the initial credit report that was furnished to the?
It does not, Your Honor.
Do you know what it said?
As to what the report said,
Yeah.
I think the report just said it reported a $750 debt. I don't think it explains the full nature of everything in the credit report.
I thought it was closer to 1,200.
I think it was 1,200 total. They reduced the amount by 500 of the security deposit, leaving, I think, a 700 and some change dollar balance.
Oh, balance, I see. And that's the report. So they call up Ansley. There's nothing about a stove or wall or anything else or painting. There's just a claim, and they call up and they check with Ansley and they verify the claim, right?
Yes, there's communication back and forth between Ansley and Carter Young about the Ms. Roberts dispute.
Yeah. And so then they report back that it is, and they say it's disputed.
That's the facts in the
Now, is
complaint.
there anything in the initial complaint or the response that refers to a stove?
In the, there's only one allegation in the complaint that references the stove, or the stove not being replaced or repaired. Excuse me, not being replaced.
No, I'm talking about reporting. In other words, was there a report about the stove, and was there an objection about the stove?
There's a dispute notation on the account, so the credit report reporting as disputed. Now, if Ms. Roberts wanted to add, it's called an explanatory statement, the 1681I allows her to then send a notice to the CRA saying, this is why I don't owe this. And so she has that other remedy to have that notation added to her credit file. That's not alleged in the complaint, but that's an additional remedy that the FCRA provides Ms. Roberts in addition to the account itself being marked as disputed.
So, counsel,
Well, that doesn't quite get, my question is, does the record show that the initial credit report and the investigation and the re-reporting in any sense mentioned a stove?
The credit report itself, no, Your Honor. And it wouldn't. It's just how the nature of how credit reporting worked. It is merely, basically, I can give you some context.
Did your files contain any reference to a stove?
It has, it's not in the complaint, but outside of it, and if you want me to go off the record, I can answer that, but there's nothing in the complaint about what was in our files about whether or not the stove was repaired or replaced. And,
counsel, can I ask a question about how the statute works a little bit?
yes, Your Honor.
Yeah, in S2B1 is what we're looking at, and it goes through A through D about what's supposed, A through D about, the duties, and we've been talking about that a little bit. But E introduces a new phrase, which is cannot be verified. And so I'm trying to figure out how that works. That was added later. It seems to, they're saying whether it's accurate and incomplete, and then we have this new section that says cannot be verified. So going back to my hypothetical that the only thing at issue is whether the stove has been replaced or not. Landlord says, yeah, I replaced it. You go check. Landlord says, yeah, I replaced it. And you said, okay, great, just send me the invoice and we're all good.
Mm-hmm.
Well, I don't have an invoice. Is that where we have a objectively and readily available, verifiable issue?
Correct, because I think
But we have a he said, she said, and it hasn't been verified. I'm not talking about whether it should have been replaced or not. I'm talking about whether it was.
so the example I keep thinking of is pay history. So somebody disputes a debt saying, I paid this.
Yeah.
And so I think that goes to, that's something that's objectively readily verifiable.
Right.
Did a payment happen or not?
And if
so,
I say I paid it, he says I don't have it.
and so, yeah, so in your, so what it would be is that fact can be determined. We go back to the creditor. For some reason, the creditor had lost their payment history. So that is a situation where there is an objectively readily verifiable issue. We just can't verify it because of lack of evidence or some other
And
thing.
you got to take it off the report.
Yes, Your Honor.
Okay, all right.
I see that my time is about to end. If there's any other questions, I'll wrap up. I would like to say, our contention is that Ms. Roberts' dispute was not objectively readily verifiable. Therefore, it was not about accuracy under the FCRA, and the FCRA does not apply. For these reasons, Carter Young respectfully requests that the district court be affirmed.
Thank you, counsel.
Thank you, Your Honor.
Ms. Ochterlony?
I'm Sarah Ochterlony. I represent Amicus ACA International, the Association of Credit and Collection Professionals. We represent approximately 1,800 creditors, collectors, collection attorneys throughout the United States. And we're interested in this matter because if the court adopts the CFPB's view of the dispute investigation procedures. It will create systemic risk to the consumer credit reporting system and cause credit report information to be less reliable. From a compliance perspective, in my view of reviewing the information, which admittedly is more than what you have available on the record, Carter Young followed industry best practices. When the dispute was lodged, it reviewed the underlying agreement. It verified it had a valid contractual basis for the damages charges, and it reviewed the documentary evidence supporting the charges and verified the furnished data. Now, these are all steps that are required in the Fourth Circuit when a furnisher is conducting a reasonable investigation, going to the underlying account documents, asking relevant information, communicating with the creditor. So they followed what we would call industry best
So,
practices.
counsel, can I ask you about this issue regarding the stove? And I know we've been talking about the stove ad nauseum, but
Yeah.
and I know there's a dispute apparently about the timing. The complaint does allege that that Ansley never even replaced the stove, but there's a question as to whether or not that was the basis for the dispute. Those are two different things. But let's assume that that was the basis for the dispute. You've rattled off a bunch of things that a furnisher is obligated to do. Do you agree with your co-counsel that if that had been the allegation on the front end, that the furnisher would have had to investigate that claim?
So, yes, and let me give you a little bit of background, which will help provide context. When a account is furnished to a credit reporting agency, it's furnished in something called Metro 2 format. It's very prescriptive about what can be furnished. It's dates, it's yes, no's in columns, it's names of people. So the details of the underlying debt, such as a stove, damaged carpet, damaged walls, would never be reported to the credit reporting agency. It's basically the number of $712 that's due. And so when a dispute comes into the credit reporting agency, they use another system called the eOscar system, which then automatically transfers that information to the credit information furnisher. So the only information that the credit information furnisher gets is from this automated system, which may not necessarily have the details about the stove, the details about the handle, and what have you. There's all these populated fields that get checked off, and there's really not a lot of opportunity for detail unless the consumer themselves sends in documentary information to the credit reporting agency, which then gets transferred electronically to the furnisher. So all of these details that we have now, because of the complaint, because we've spent years doing this, were not available to Carter Young when that initial investigation request came in. So but what they were able to do was go back to the original creditor, the apartment building, and say, hey, give me your information about this debt that's due. And so what they did actually receive was the underlying lease agreement that, yes, indeed, provided for the damages to be charged to her, provided for them to keep the security deposit, and they also received a very detailed inventory of the damages that were done to the apartment. You know, the type of thing that somebody going through the apartment would write down and say, you know, pet urine on the floor, a stove / needs replaced, those types of items. So when Carter Young got that documentary evidence, it said on it, needs replaced. Now, what happened subsequently, we don't know. Perhaps the stove, they did find some other repair, they did find some other way to manage the situation. That's entirely possible, and that's exactly why we have the state court claims system in order so that the consumer and the original creditor can work those details out.
And just to interrupt you, and this is helpful, but if it goes just, I mean, you know, it could have said, I mean, at least hypothetically, it could have said that information it gets from the landlord could say replace stove. And it might, and the tenant may say, you didn't replace the stove. I mean, what I'm trying to figure out is if they go to the landlord, they have the information you're talking about with a slight hypothetical modification that said replace stove.
Right.
Well, if you look at just what the landlord says, it all looks kind of, you know, in order. And so but the tenant, whether or not the landlord's, it's been reported this way or not, is saying that's completely wrong. There was never a replacement stove. Is there an obligation for the furnisher to find out whether that is disputed as to ever happening or not?
So I think that's the beauty of the readily verifiable objective information, because had the consumer provided a picture or an affidavit from the mechanic who ended up fixing the stove instead of replacing the stove, some sort of objective information.
So you're saying the tenant has to prove, how would the tenant prove that someone's claim that they replaced the stove is false?
Well, the same way that they would do so in court, which is how they ended up going in this case as well.
Yeah, but
Right.
we're talking about a statute that requires an investigation. I mean, Congress passes this stuff. It may be hard to operate the way y'all do your computer systems or not, but
Yeah.
we don't, that's people's choices. And Congress says you have to investigate, and y'all are advocating, both amicus and the defender, saying this objective and verifiable standard. Makes some sense to me.
Right, so.
But let me finish
Oh,
my
please.
question. But the question, but if you're going to say that standard exists, in some way or another, you got to give the process an opportunity to, for the dispute to be explained.
So I would say that by the furnisher going back to the creditor and getting that apartment checkout list that had a very detailed description of the damage to the apartment, which was significantly more than just a stove. That type of relevant, simultaneous detail about the damage to the apartment is objective and readily verifiable evidence.
But if it's completely false and they get a document that makes it look like they replaced the stove, there's not an opportunity for that to be investigated? Is that your position?
Well, I would say that when you have objective evidence that suggests that, and that performs a sufficient basis for the furnisher to believe that the debt is valid, which is what the statute requires, so they have evidence objectively that says sufficient basis to report the debt. There are ways to overcome that, but the ways to overcome that is not the ipsa dixit of the consumer saying, oh, something else happened, I don't owe the debt. The way to overcome that is other equally objective, ratifiable evidence.
But the statute says in E, unable to verify. And so that, to me, suggests there's objective and readily verifiable issue, like the stove wasn't replaced. And, we've been through all the hypos, but it sounds like the way you do it, if the landlord has documents that look in order, that's all it's got to do.
Well, an eyewitness
Is
report.
that yes?
Yes, yes.
Okay, so if you put forth a list that says I replaced the stove and somehow, and the consumer says, no, you didn't, having a document that looks like, that has replaced stove on it is enough.
In this situation, that would be enough because it seemed like eyewitness reporting documents that substantiated the claims.
It's just the fox guarding the hen house.
Well, there's got to be a limit because we're doing tens of thousands of these a day, right? So,
That's fair.
and this is why this is why this line seems to make the most sense. But this is also a great situation for you to analyze this issue, because indeed the consumer was able to resort to state court remedies of the small claims court in order to, manage that several $100 dispute. And so that is still always, that process has and always will be available to the consumer when there is some sort of underlying dispute. And once we have that settlement, once we have that judgment, that's the objective evidence that then can go to the furnisher that has them change the way that they report the information.
All right, thank you, counsel.
Let me just start by saying that what industry counsel, everything she represented about what Carter Young did, none of that's in the record. None of it's in the complaint. We don't know at this point. Carter Young's position is not that it investigated, but that it didn't have to investigate. So I don't think any of that is relevant. There's a couple of points I want to make in response to what was said is about first of all, about what evidence they need. This court's decisions in Doherty, which is in the brief 701 Fed Appox 246, says the determination of whether a furnisher's investigation was reasonable is based on an evaluation of information within the furnisher's position, such as correspondence between the consumer and the furnisher, the data identified by the reporting agency is disputed, and the furnisher's other records related to the disputed account. So if you look at the complaint, we allege that without detail, but we allege that we, in addition to the automated, whatever the CRA furnished or provided, we provided direct information, and through the CRAs, information, lengthy emails explaining the basis of the complaint and the reasons why we contended it was false. So there's an open question, and at least the complaint places an issue that there was lots of other information that they could have consulted. And it certainly, we can't dismiss the
Well,
complaint.
let me ask you this, just, it has to be hypothetical because of your observation about the record. Let's assume that the report to the reporting agencies was that your client owed a debt of $712 from the landlord. And then Carter receives a dispute. Carter calls up the landlord, and the landlord supplies the lease and supplies the invoice, detailed invoice of the charges, and gives that to Carter. That's all they have now. And then Carter reports back that it's a legitimate claim, but it's disputed. What else should it have done at that point? There is no objection. There was no objection from your client, which lists the nature of the dispute, which your client, according to the complaint, said it was fraudulent and retaliatory. That was the complaint.
Yes, and at various points, I mean, that it was purely
So
fictitious.
they go and check whether it was fraudulent, and so they get a copy of the lease, and they get the invoice. And then they ask whether it is retaliatory, and they can't determine that, whether it's retaliatory or not, because the indication is they got the lease and they got the invoice for a detailed invoice for the damages. So they report back that the accuracy of the report was accurate. Now, I'm having trouble. You know, it's an after the fact whether they replaced this or was necessary. That all goes to some kind of litigation-like process, which I don't see in this context is called for.
Well, the allegation, based on this complaint, Carter Young had in his possession, at the time of what it was supposed to be investigating, the contention that the stove was not replaced.
No,
So,
they don't have that. The complaint, as you alleged it, the complaint, your client sent in a notice that said the claim was fraudulent and retaliatory. That's what she said.
But it's not limited, based on Doherty, it's not limited to what the
But that's
CRA.
the charge that Carter gets.
That's what they get to begin with. But
That's what they get to begin with.
But
So
during this relevant
Hold it now, just go. That's all they get from the reporting agencies. It comes back to them.
Okay.
The charge is fraudulent and retaliatory. So now the question is, what duty does the statute have to investigate that? So what they do is they go back and they ask about whether it's fraudulent or investigatory, and the landlord provides the lease and the detailed invoice. There's no suggestion about any item on the invoice because we don't know all the matters on the invoice. You address only one. But they address the invoice, and they see the invoice, and they report back that it's not fraudulent, there is a claim, and it's disputed. At that point, what should they do? They don't have no knowledge about a stove.
But they do, but that's not.
It's on the invoice, it's one of the list.
But this says that they have to consider correspondence between the consumer and the furnisher, and there's multiple allegations about us providing detailed explanation. No, it doesn't say what we told them in the complaint, but I don't think we were required to tell it. But you can't decide on a motion to dismiss that they didn't have any information in their possession to show that this was, that the charge for the stove, that was the big heart of the whole matter.
What was hard was that it was, quote, fraudulent and retaliatory. That's what they were investigating.
Yeah,
And the question is, how do they resolve that claim? And so they went ahead and conducted this investigation and got the information that indicated that it was a real claim. It was authorized by the lease, and it was itemized. The damages were itemized, and they saw the damages, a list of damages, $712, or $1,207, whatever it comes out, because it had to be 712 plus 500, the list. And that's what they see, and they get. And so now the question is, unless they go and verify every charge, and of course, that's been my question from the beginning, do they have to go down that entire list and verify every charge? They basically see the invoice, which was a business record that was issued and delivered to the lessee, purportedly under the lease. I don't understand at this point. I mean, Carter is a furnisher trying to solve its statutory duty, but
but you're assuming that it's doing
there was
things
no
that,
evidence of notice to Carter that there was a stove damaged and not repaired, or charged for and not repaired. That you alleged on information and belief. Later, it turned out the stove was not repaired or replaced. But that's not part of what Carter was faced with.
well, I think the information, we don't know the full scope of the information they had, and I don't think that we were required to plead everything that was provided to them, but our position
No,
is
but you
that,
need to plead a cause of action.
yes, and we pled that and the cause of action is that we disputed it and provided, and the furnisher notified and they didn't investigate. Their position is they never checked the lease. Their position is they didn't have to. I know my time's out. I just would refer the court to Penner versus Schmidt, a Fifth Circuit decision in our.
This is what I see in the complaint. This is the only thing Carter had. On or about August 2, 2022, plaintiff filed a formal dispute with Experian, alleging that the Ashley claim was fraudulent and retaliatory. Upon information and belief, Experian promptly reported this dispute to defendant. That's what they.
There's
that's what Carter-
subsequent allegations that say that we sent emails, detailed emails to them.
To whom?
To Carter Young, explaining in great detail the basis of it. These are things that are being assumed that are not in evidence and are not, not before the court. But I'll close. Just the Penner v. Schmidt involved a retaliatory charge on an account that the employee had with his employer.
Can you
And
just point where you made these, provide this information to Carter? I'm looking at pages, I'm at the complaint, J9, 10, in that area.
well, on September the 20th, this is page Joint Appendix 10.
Yeah, I'm with you.
Okay. Let's see. No, excuse me, on page 11, Joint Appendix 11, paragraph 40, the plaintiff called the defendant directly, informed the manager of the lawsuit. Later that day, a lengthy email was on paragraph 41 was sent attaching that and describing the claim. On September
Well, by then, you'd filed a lawsuit, a small claim.
No. The lawsuit wasn't filed until December of 2022. So no, this was all
It says
before.
on September 20,
That was a small claims lawsuit against.
plaintiff filed a small claims lawsuit against Ansley in the bond.
That was the landlord, not Carter Young. Carter Young was not a party to that. Then on paragraph 45 on September 26, additional email provided additional information regarding the charge. So there's lots of emails and correspondence that went back and forth that are not in the record, but that are at least alleged that were in possession
Well,
of.
that email said that an explanation as to the fraudulent nature of Ansley's claim and suggesting that the matter could be, with defendant could be resolved, would at a minimum temporary block and to lead to reporting of the claim pending resolution of plaintiff's lawsuit.
Well, if the stove wasn't replaced, then in our view, it was fraudulent.
That's not there.
Well, it's not in the allegation, it's not specifically, but it's not required to give every little element of the email. our position is that they had in their possession, they knew that the stove had not been replaced. I've gone well beyond my time.
Thank you, Mr.
Thank you.
Roberts. Thank you all for your arguments. We'll come down, recounsel, and move on to our final case. Our final case, 21-6992, United States versus Powell. I think also involves a lease agreement, but thankfully not the FCRA. So, Ms. Maloney, go ahead.
Good morning, and may it please the court. Morgan Maloney for the appellant, Mr. Nathaniel Powell. Mr. Powell's sentencing counsel failed to do the bare minimum. He failed to investigate a lease, and Mr. Powell is paying for that error with years of his life. Mr. Powell has met both elements of the Strickland test. First, because he failed to investigate the lease, a key piece of evidence handed to him on a silver platter, sentencing counsel's performance was deficient. And second, because this failure caused the sentencing court to rely on the wrong guidelines range at sentencing, under this court's decision in United States v. Freeman, that deficient performance prejudiced Mr. Powell. So turning to Strickland's first prong, performance. At sentencing, the government bore the burden of demonstrating that Mr. Powell, 1, maintained a premise, 2, for the purpose of distributing narcotics. Prior to sentencing, Mr. Powell told his counsel that the apartment wasn't his. He told him that Ms. Wilson, the government's sole witness, was lying, and that the apartment wasn't used for the purpose of distributing narcotics. Yet following that conversation, defense counsel did nothing. He made no factual investigation whatsoever into the basis of the premise enhancement. At sentencing, the government's evidence in support of the sentencing enhancement was slim, at best. The government relied solely on the hearsay testimony of Ms. Wilson, a known drug addict and co-conspirator, as told by the government agent, Agent Dyer. Simply put, sentencing counsel failed to put the government to the test. If entered into evidence, the lease would have done 2 things. First, it would have been an important factor in the fact-intensive analysis of whether Mr. Powell controlled access to the premises. Second, it would have undermined the government's sole piece of evidence. Again, the hearsay testimony of Ms. Wilson. With so little evidence on the government side of the scale, there's a reasonable probability that the lease could have tipped the scale in Mr. Powell's favor.
Well, control of a premises, I grant you one easy way to prove that is by virtue of a lease agreement, but that's not the only way, right? And so wasn't there other evidence in the record supporting at least constructive use of the premises?
Your Honor is correct. There is another way to meet the maintenance prong other than just proving possessory interest. But that's a fact-intensive analysis, as this court has told us. And in other times when this court has upheld the premise enhancement, for example, in United States v. Clark, the defendant had control of the premise, a key to the premise, bought an extra big gun to control access to the premise, and under plain error review, this court said that that case was a close call of whether the premise enhancement applied. So here, the government didn't put forward any evidence of that case, and furthermore, the lease would have undermined the government's sole piece of evidence. Again, the hearsay.
Is the district court's decision seems to say that the counsel, instead of pursuing the lease, used other, impeached the testimony in different ways. And so I'm trying, and there's, I mean, the counsel said that. He said, and I'm familiar with this district. I've been here years practicing law, practicing criminal law. I'm familiar with the judges. They oftentimes apply this enhancement when, outside of a lease or ownership context. Given the reality from practicing law for years, that's not an effective use of, that's not the best way to impeach, or it's not a necessary way to impeach. And, we could criticize that. Obviously, you disagree with that. I respect that disagreement. Does that, though, fall in a counsel's, ability to make strategic decisions about how to impeach or not?
So thank you, Your Honor. No, it does not.
Well, why is that? It
This-
sounds like a strategy. I know what the courts do. That's not worth my time. I can do it this way. Why isn't that classic what lawyers do every day who have to make decisions on a bunch of cases?
Because in this case, sentencing counsel didn't do any factual investigation whatsoever. As this court told us in Elmer v. Osment, the failure to investigate, the failure to do a factual investigation cannot be overcome later by the defense.
Other than the lease, what would you point to that he could have used? I mean, he spent a fair amount of time on that enhancement as well as others. He had, 3 or 4 enhancements he had to address. And actually, he spent more time on another one, which he thought was more serious. But he did object to it. He did cross-examine. He argued it to the court. It seemed to me he didn't bypass it at all. He spent some time, but he recognized that the facts for that enhancement were coming from this woman through hearsay, and he attacked that, or tried to attack that. The question, I guess, is who else or what else should he have set aside the lease? Is there anything else he could have done other than what he did? I mean, he did a fair amount of response to that enhancement, or it's a 2-level enhancement.
It was, yes, Your Honor, it was a 2-level enhancement. Well, in this case, the lease is the only thing that's come in at the evidentiary hearing below. But Mr. Woodward had the obligation to do at least a cursory investigation into the premise enhancement. And even that cursory investigation.
Well, I know, but what did you purport that he would have done? Who would he talk to or gone to or what? We already have the testimony of the one person that's in the record and was in some detail about the transactions at the apartment. What did you think he was required to do?
He was required to find the lease, Your Honor. He was required to find the lease, a legal document, a fairly easy and readily accessible piece of paper to prove that his client didn't have a possessory interest in the apartment.
Well, the lease, all it would have proved was that if, at best, it seems like, is that Brown was not the tenant prior to January of whatever the year is.
2016, Your Honor.
2016. So it might have proved that. Mr. Powell, when he testified, didn't say anything about, okay, I wasn't using that premises before January 16. Didn't say I haven't used that premises for drugs. They just challenged the existence of the lease. So that's something. I mean, it undermines, Wilson to some extent, but it doesn't disprove Wilson. It just says maybe there's a question there because Brown's lease was only for a shorter period of time. We don't know who leased it before. It may have been someone else. And my point in that is Mr. Powell testifies and he doesn't provide any. You would think if this is all made up and it just all started in January, he would say that. He didn't say that.
Well, Mr. Powell told his sentencing counsel before sentencing that the apartment wasn't his, that he didn't use it, and that Ms. Wilson was lying. But in this case, this lease would have been a key piece of evidence in this fact-intensive inquiry. And when the government's evidence is so slim, like the government's evidence was in this case, I mean, again, this is the hearsay testimony of a drug addict.
Sure.
And the lease also would have undermined Ms. Wilson's statement that she went to the same apartment for a period of 5 years. As we see here, the lease was only valid for 5 months prior to Mr. Powell's arrest.
What about the district court saying that, basically, that there was testimony to support the enhancement, that Wilson's testimony was enough, and then saying that I would likely have applied the enhancement either way. Yet, particularly on that second point, we have an opinion, Freeman, that I know you know about.
Very intimately.
But I was going to say I do too. That seems fairly different because in Freeman, the sentencing judge at the end of the sentence said, if I'd made any mistakes here, I would do the same thing. Which, we said that, look, you can't do that. You can't just at the end of the thing have a prophylactic statement that immunizes any mistake you made. But here we don't have that. Here we have the same judge who applied the enhancement looking at the specific challenge and would say, despite that, I would do the same thing. That seems in face of that testimony. I'm just trying to figure out how you can say, A, it's not different than Freeman, and B, how you're prejudiced.
Well, I think that this is very similar to Freeman. First, for a couple of reasons. One, just like in Freeman, here the district court is essentially immunizing its own error on the prejudice analysis. The prejudice analysis is a legal analysis that this court should review de novo. Second of all, Strickland tells us that the prejudice analysis is an objective analysis into what a sentencing court would have done, not an analysis into what this judge would have done had the circumstances been different. So for that reason, the district court statement of what the district court would have done had the circumstances been different shouldn't be given any more credence than any other legal conclusion made by a district court. So it's subject to de novo review. So here also, when we were asking the question of strategic choice, the sentencing counsel said at part of the 2255 hearing that in a scope of a case like this, 2 points wasn't going to be make or break. That's not the case. Those 2 offense level points increase the top of Mr. Powell's guidelines range by 9.5 years and the bottom by 5.5 years. This isn't a case where there's a rounding error. This is at least half a decade, if not almost a full decade of a man's life. And sentencing counsel didn't even look for this piece of paper, this legal document that could have been, there's a reasonable probability that this document could have tipped the scale into Mr. Powell's favor. And again, Freeman
Well, it's
is...
not only that he didn't look for it, right? There was evidence that he was handed it. And
Mr. Powell said that he told him about it, that he brought it up again at the sentencing hearing, that he asked his girlfriend to fax it to him. Now, the district court doesn't make any factual finding.
Well, and that's part of the problem, I think. The district court, it looks like just went straight to the prejudice prong and tried to, as you described it, insulate the analysis by saying I would have done the same thing anyway, it wouldn't have mattered. But it would have been quite helpful if we'd had some findings.
Yes, Your Honor, they would have been helpful. But in this case, it doesn't, whether or not Mr. Woodward ever actually received the lease and whether or not the lease ever made it into his file or not, a reasonably diligent counsel should have looked for the lease independently. And here, again, Mr. Powell is saying that he's essentially screaming at his counsel, find this lease, find this lease, find this lease. And he asks his girlfriend to fax it. Now, Mr. Woodward says he would never swear under oath that a piece of paper couldn't get lost in his office. Whether Ms. Brown didn't send it or it didn't go through or it somehow didn't end up in his file, regardless, he should have looked for it and he should have found it. This isn't some incredibly hard hidden evidence. This isn't some complex forensic search. This is a legal document. that a simple call to the apartment complex, he could have gotten it.
Is there evidence in the record that, well, the court again didn't make any findings, but that Mr. Powell was the lessee of the premises?
There is no record, there's nothing that suggests that he was the lessee of the premise.
So what would this fact then refute? I mean, the existence of the lease refute, if there wasn't any evidence suggesting that he did rent the premises?
So it would undermine, again, Ms. Wilson's testimony. So Ms. Wilson's saying that she's going to the same place for a period of 5 years, but the lease was only for a period of 5 months. And again, in a case like this, where there's so little evidence on the government side of the scale, this would have undermined Ms. Wilson's credibility.
But why does it necessarily undermine her credibility? It undermines her credibility only if the position is Ms. Brown has been the tenant those 5 years.
Well, yes, Your Honor, but it raises and complicates a very key question of, okay, well, if there's a lease for 5 months, how was this happening for a period of, 4 years and 7 months
Did
before
Powell
that?
put in the record that I haven't been there for those 5 years?
Mr. Powell tells his sentencing counsel that it wasn't his apartment and that he wasn't using it for narcotics. Now, it's his girlfriend's apartment. I mean, I think he's going to it.
Did he say when he testified at the hearing that I was only there from January on?
At the hearing, that wasn't a question that was asked or a
His
topic.
counsel didn't ask him, and nothing caused that to come up. All he did is talked about the lease, right?
To my recollection, Your Honor, yes.
Okay.
And he talks about what he told his counsel and what he asked his
Right.
counsel to do. So I see my time is almost up. Does the court have anything else?
Thank you, Ms. Maloney. Mr. Kapoor?
Good afternoon, Your Honors, and may it please the Court. Batan Kapoor on behalf of the United States. The Court should affirm the denial of Mr. Powell's ineffective assistance claim, as he has failed to meet his burden on either of Strickland's prongs. His counsel's performance was reasonable. Before sentencing, Woodward met with the defendant several times to discuss the PSR and Mr. Powell's objections. Powell wanted Woodward to object to the application of the premises enhancement. Woodward did so. Powell told him the basis for the objection was that Valerie Wilson was lying. So Woodward took reasonable measures to attack her credibility, first in the sentencing memo, then in cross-examining Agent Dyer, and then again during argument. Nothing more was required. The defendant cites no case supporting the proposition that a lawyer who objects to a sentence enhancement and zealously argues against the enhancement for the reason the client gave him can still render a performance that is so unprofessional as to make it constitutionally deficient. That is enough to affirm.
That strikes me as a pretty limited sort of view of what a lawyer should do. Sure, you listen to your client. He tells you a reason why you think a particular line of defense is viable, and you certainly pursue it, but you're suggesting that that ends the inquiry as far as the lawyer is concerned?
In the context of evaluating whether the performance was so deficient to render the adversarial process defective, yes, Your Honor. Again, I think the inquiry here is not, did counsel make errors, or was there some more that he could have done, or did he get a C+ in his representation of Mr. Powell? The question is, did the adversarial process itself break down? And I think the important point to remember here is the parties agreed that the key issue with respect to applying the enhancement was Valerie Wilson's credibility. Both sides agreed that the application of the enhancement was based on her statements to Agent Dyer. So the question then becomes, okay, how should this lawyer go about undermining the credibility of the government's sole witness whose statements are presented through Agent Dyer? And Mr. Woodward uses the same lines of attack that Mr. Powell continues to maintain. Valerie Wilson's a drug addict. Her statements are unreliable because she's a co-conspirator, so she has an incentive to maximize her value to the government. It's in that context that we're arguing that nothing more is required. Another point to make here, Your Honor, is that it's not entirely clear what the lease would have shown. So to begin with, Mr. Woodward refutes the idea that he was aware of the lease, that he was made aware of the lease. He repeatedly says, I combed through my files.
But what about, since the district court did not decide that issue, how do we resolve it?
There's a couple different ways, Your Honor. First, you need not make any finding on the performance prong at all if you find that Mr. Powell wasn't prejudiced by the representation. So one option you have is just to simply not address it. If you did want to address it, the district court actually does make several findings that could give you comfort on the performance prong too. I mean, first, in the evidentiary hearing, she notes that, because she's had experience with Mr. Woodward over several years, he's a, quote, honorable man of this court. He'll tell us that he has this in his files. I'll also point out that when Mr. Powell was testifying at the evidentiary hearing, he actually provides statements that bolster Valerie Wilson's credibility. He agrees on cross-examination that he supplied Valerie Wilson with drugs multiple times over several years. That's at the joint appendix at 344. What that fact shows is that at least part of her statements were credible. She's saying, I went to this place since 2011 to purchase drugs on several occasions, and he's acknowledging, yeah, I supplied her with drugs multiple times.
Well, that's all the more reason to try to find other avenues to attack her credibility.
And again, Your Honor, if you think that Woodward made mistakes in his representation, errorless representation is not the standard. The standard is, was his performance so unprofessional that it fell below what the Constitution requires? And even if there were other possible avenues to impeach Ms. Wilson, to attack her credibility, now we're arguing over selected strategy. And in Strickland itself, the Supreme Court counsel cautioned that the purpose of this inquiry is not to sort of have a second trial and this trial be about counsel's unsuccessful representation. The purpose is, with respect to the sentence enhancement, was what the district court presented sufficient so that there was adversarial testing of the facts?
What's your, help me a little bit on prong one with your argument. Are you arguing, you began by saying that the standard for ineffective assistance is high and Mr. Woodward's representation did not rise to that level even if it wasn't perfect. Paraphrasing, but basically that. There's, as you were just kind of alluding to, there's another concept of strategic choices, and that can really come in and maybe even make it even more difficult to show ineffective assistance if it's a strategic choice. Is your position that he did make a strategy decision, that sort of deference we apply, or that he may not have been perfect and he just didn't rise to the level? I'm trying to see if you're employing the strategy argument.
Well, it's kind of both, Your Honor. So there's two options. You can either believe that he did have the awareness of the lease at the time that he's beginning to prepare for sentencing. Mm-hmm. And what we're arguing is if you think he was aware of the lease, or he obviously should have been aware of the lease, then it still would have been a reasonable strategic choice to say, okay, sure, Ms. Brown had this lease in her name from January 2016 to January 2017. I'm not really going to do anything with that fact. And that would have been a strategic choice that would have been.
And what's the strategy behind that?
One, because there's a risk that if Ms. Brown is called to the stand, the government can cross-examine her, can ask the questions that Your Honor was asking about, well, who had the lease before you did, or did Mr. Powell ever come around?
Does the counsel have to identify that, reason not to introduce the lease? I mean, Chief Judge Diaz just said, what's the downside? You're articulating one for that strategy deference to apply. Does the counsel have to say that's why I didn't do it?
No, Your Honor. To my knowledge, there's not a requirement that the sentencing counsel affirmatively walk through sort of every aspect of his strategic thinking. He does give us a flavor for it in his testimony at the evidentiary hearing when he says, in my experience, I'm paraphrasing his words, but he says, in my experience, defendants will have a safe place that they will likely use to keep narcotics in. One thing we can infer from that is it's not unreasonable to think that a drug dealer would have a premises in a girlfriend's name, in someone else's name that he thinks of as a safe place to keep drugs in. And And again, we get flavors from the evidentiary hearing where Mr. Ruder is basically saying, I just don't think that the possessory interest is that key to the inquiry when you have these other indicia of maintaining the premises for the purposes of distributing drugs. And again, going back to Valerie Wilson's statements, which is the only basis for the application of the enhancement, she's saying, I came around to this apartment a dozen times since 2011, and on one occasion, I saw him take delivery of a large quantity of heroin, and I heard him go to a back room and use either a blender or a grinder to cut the drugs. So in that context, even if you're assuming Woodward knew about the lease or should have known about the lease, it's just not very clear what going down that rabbit hole was going to do for the application of the enhancement. Instead, I think he quite reasonably said, okay, if Ms. Wilson is in fact lying, let's show the district court the reasons why she has these incentives to lie. The other point I'll make on the performance prong is the duty to investigate should be evaluated in the context of what's going on. Strickland tells us that the duty to investigate is evaluated in the context of the circumstances. And here we're talking about a sentence enhancement to the advisory guidelines range. I think the cases that Mr. Powell cites are instructive because they show that this duty is sort of matched to what's at stake. So in Elmore, for example, there was forensic evidence that was, quote, always and obviously vital to the government's entire case. And defense counsel didn't investigate that at all, instead relying on the trustworthiness of the forensic lab. And so Elmore in that context says you can't just fail to investigate this key piece of the government's entire case. Here we know that the lease wouldn't have made that much of a difference. One, because the district court told us, having expressly considered the lease and testimony. So at the evidentiary hearing, Mr. Powell now has a different counsel. Counsel presents what the lease would have said, presents what the testimony would have been, and it's after that that the district court makes the finding, yeah, I still would have found Valerie Wilson credible, and that credibility finding was reasonable.
Well, your colleague on the other side said that it's not a subjective test, it's an objective analysis, and so it doesn't really matter what this particular judge would have done, but what a reasonable judge would have done. So do you agree with that?
I don't agree with that, Your Honor, because the district court was the fact finder and would be the fact finder on remand, so we know what kind of factual findings she would make. But even if you do agree with that and just look to this court's case law and assume, say, for example, you were just making the determination based on the record, numerous cases from both before the time of sentencing and since confirm that the possessory interest really wouldn't have mattered because of the other indicia that Mr. Powell was using the apartment to store drugs, to distribute drugs, and to sell drugs. So, there's Christian, Holloman, Clark, Lothar, Stukes, and a variety of other cases that we cite in our brief, where even if it was a different fact finder, presented with the same set of facts and the lease, Mr. Powell puts the lease on and says, look, Ms. Brown had the lease from January to January 2016 to January 2017, and then the government says, here are Valerie Wilson's statements. You could still make a finding that Valerie Wilson was credible. And again, like I said, the government could then go on and say, well, actually, doesn't it make it more likely that this house is being used as a stash house, at least for 2016, because it's in his girlfriend's name, citing cases suggesting that it's quite common for a drug dealer to use an apartment or a home that's leased in a co-defendant's name, a co-conspirator's name, a family member's name.
So if hypothetically it is an objective inquiry, we would then need to decide whether the district court statement that it would have done the same thing is objectively unreasonable. I mean, isn't that the implication of what, I mean, I know you're saying you don't think that's the case. You say it's, but then you said even if it is, you'd say it's subjectively unreasonable. I'm trying to look at it a little bit different way, which is whether an objective standard would require us to say that what the district court said it would do is objectively unreasonable.
If I understand Your Honor's question correctly, I think if you did find that it was an objective standard on the prejudice prong, you would still have to go back and say, did Mr. Powell meet his affirmative burden of showing that there's a reasonable probability of a different outcome? And then you would evaluate any factual findings that were already made for clear error. So the facts that existed before the evidentiary hearing, Valerie Wilson's credibility, the district court's credibility determinations, were those clearly erroneous? And then you would have a de novo review of the actual legal conclusion. So you'd still be looking at the facts that existed in the record and evaluating the credibility determination under a clear error standard with the extra deference that's given to the credibility finding.
Can you talk a little bit about the prejudice prong of this claim? Because in most cases, district courts and we sometimes go straight to that issue and assume deficient performance and decide on the basis of the record whether the result would have been different, whether, i.e., the defendant was prejudiced. And we have some indication from the district court that it probably would have imposed the same sentence. I forget the exact language. And Judge Quattlebaum talked about our Freeman opinion because, and in that context, my first instinct was, well, if the district court is telling us that this all would not have mattered because the sentence would have been the same, then, why are we here, assuming that that's not unreasonable? But Judge Freeman suggests that we don't do that in this context, and Judge Quattlebaum explained why he thinks this case is different. Do you think this case is different?
Yes, Your Honor. I think it's important to understand that Freeman occurred in a very, very different context. And I think the factual context there is the reason why this court said, a passing sentence from the district judge that says, I would have imposed the same sentence either way, doesn't immunize the decision from further review. So in Freeman, the district court never had the opportunity to have any adversarial testing of the facts in the PSR. And that's because after initially raising objections on the day of sentencing, counsel affirmatively waived those objections to the PSR. And so the district court just adopted the findings of fact in full. Another key difference with Freeman is this court found that counsel's performance was so deficient that on a direct appeal, it could find there was ineffective assistance. There the court said that the counsel was unequivocally wrong on the law. So not only was it that he intentionally, waived the objections, depriving the district court the opportunity to consider, are the facts in the PSR accurate? Should there be some testing of it? But also the court found that he was just clearly wrong on the law. Here, the district court considered the PSR, the findings from the PSR, the statements from Valerie Wilson. It also considered what effect the lease may have had, and it's far from clear that Mr. Woodward's theory that the lease wouldn't have mattered is clearly wrong in the law. In fact, I'm not aware of any case where, there's evidence of a drug dealer using a premises for the purposes of drugs, and then he puts in evidence, well, actually the lease was in someone else's name, and that fact has become dispositive. So both because the law doesn't strongly suggest that counsel was wrong, and because the district court has had the opportunity to consider that alternative world of the presentation of evidence, that you can rely on the district court's statement that it would have applied the enhancement either way, and that even if it didn't apply the enhancement, it still would have issued the same sentence.
Well, it's that latter conclusion that I wonder still applies in light of Freeman. That's what I'm getting at is we said that it didn't there, but you say that it does here. It has some weight here.
I think it can, Your Honor, because we know that and again, I understand that in Freeman, the court said, the fact that the district court says they likely would have imposed the same sentence doesn't matter. But here in the sentencing transcript, you see a lot of evidence of this being an individualized determination where the sentencing guidelines didn't have the same degree of anchoring effect that they would have in a usual case.
Counsel, back to before, I know I want to hear what you're saying about the individualized part of the sentence, but before you get there, just following up on Chief Judge Diaz's question, that you alluded to this, but in Freeman, the statement that I would have done the same thing anyway was not tied to any actual dispute, right? It wasn't tied to any other alleged error. It was just a free-floating statement in general. Here you have the identified error, a consideration of the evidence, and a statement that I would have done the same thing anyway. So at least on a factual statement, those are very different. Now, we still have the question of whether or not we consider it or not in a subjective versus an objective way. But it seems to me just the way the language of I would have done the same thing, and issued the same sentence is quite different.
Yes, Your Honor, that's correct.
How can you say you would have done the same thing when you don't know what the error is to begin with? I thought that was the gist of our criticism in Freeman, or at least a large part of it. Whereas here, you may disagree with that, but at least it's framed in the context of a specific issue that's being litigated and the evidence is being considered.
Yes, that's correct, Your Honor. And we know that there's been that consideration, both for the reasons that Your Honor suggested, and also because the district judge showed that, okay, the correct guidelines range would actually be this, I think 290 to 360, but then still said, I would have given the same sentence.
And last thing, and I'll be quiet, but I can't remember, but isn't there a Supreme Court case that, that does look at that harmlessness? I forget the name of it right now. Maybe that's not ringing a bell, but I think there's a Supreme Court harmlessness case that would support at least looking at whether the same result would have happened. Is that fair? I may be.
If there is, it's not coming to mind. I apologize, Your Honor.
Well, I could easily be wrong on that.
I will say Melina Martinez does leave open the possibility that a district court's statements about the sentence that it imposed can give this court comfort to say that it would have, and that's in our brief at the end.
That may be what I'm thinking. Okay.
I see my time expired, so
Thank
for the
you.
reasons we said, Your Honor, we ask that you affirm.
Thank you, Mr. Kapoor. Ms. Maloney, you have some rebuttal?
Thank you, Your Honors. To address a few things brought up by my friend on the other side. First of all, prejudice is an objective determination. In Strickland, and this is using the U.S. Reporter site, so 466 U.S. At 695, the Supreme Court said the assessment of prejudice should proceed on the assumption that the decision maker is reasonably conscientiously and impartially applying the standards that govern the decision. It should not depend on the idiosyncrasies of the particular decision makers. This is an objective inquiry about whether there is prejudice. And to return to Freeman, Judge Quattlebaum, you asked about, do we give extra credence to a statement that's made later by the district court? And the answer has to be no. If this court, as this court said in Freeman, that we don't give credence to what the district court said at the sentencing itself, then a post hoc statement of what a court could have done or would have done has to be given even less credence in this situation.
But is the timing the issue, or, again, I was just asking your colleague this. I mean, one of the things about Freeman that I think, was a basis of that decision was that the statement wasn't tied to anything. It's I would have done the same thing without even knowing what the objection was. So how do you give it much credence if you don't even know what the issue is that's being considered?
Well,
I'm sorry. My point being, I thought it was less about timing and more about the context.
Well, so this court said that there's a presumption that when the incorrect guidelines range is applied, that incorrect application of the guidelines range will be prejudicial. So the question now is, how do you overcome that presumption? And this case is not that case. You can't overcome it here. At sentencing, the court relied on the guidelines range. The court used it as an anchor for the entire sentencing analysis. The district court both starts and ends the sentencing discussion with a reference to the guideline range. And that's at JA 142 and JA 157. So the guidelines range is anchoring, as it must, throughout all of the sentencing analysis. So for the district court to later say, if the situation had been different, I probably wouldn't have done anything different, shouldn't be given any more credence than any other conclusion of law that a district court will make. And to go to the question of whether this was a strategic choice, or whether Mr. Woodward made a strategic choice or not, this is not the type of strategic choice warranting this court's deference, even if it was a strategic choice. This was made after no factual investigation whatsoever. This is not a case of sentencing counsel poring over this lease for hours and hours trying to come up with how best to use this evidence or not use the evidence.
But is that required? I mean, the counsel says that having the lease, knowing that it was for for less than a year, wouldn't have made a difference to me. I think that's what he said. I would have done the same thing and approached this the same way. So, I mean, again, you may think that's not what you should do. You should do better than that. Doesn't that, however, I'm just trying to figure out why that isn't a strategic decision.
So the sentencing counsel's post hoc explanation of trying to explain what he was doing or why he was doing it, again, shouldn't be given credence by this court. The sentencing counsel told us.
Why not? My whole reaction about the lease is that important? Is that going to make a difference? I mean, they found Powell right out there in front of when the final chase, he was at the apartment. And there were a lot of indications that he was linked to that apartment. And what difference does it make that the girlfriend had the lease or the boyfriend, he didn't have the lease? That's his attitude. And I was going to raise the question, and this prompts my question, I suppose, is it seems to me materiality comes into effect as to whether that's meaningful to this determination. While it is relevant, it is not necessary because the standard doesn't require a leasehold. It requires control and the use and maintenance of that location as a place for distributing drugs. And so I took it from his saying it wasn't important to what I was trying to show. We're stuck with Wilson's testimony. We're stuck with his presence at the place. We're stuck with the agent's explanations. I have to attack that. That's where I'm going to get this maintenance issue. That's my sense I took from it. And so I question whether on that basis, if you say he should have gotten the lease, I'd say, is that material? I mean, it clearly is not required. And my guess is in most cases, the drug dealers don't own their cars and don't own their leases. I mean, in most cases, it's usually a girlfriend or something like that. It's for a lot of reasons, as you might expect. And so if you've been in this business for a long time, you say, well, what difference does it make? That's what I thought his attitude was, which is a judgment call.
My time's expired.
Yeah, no, please respond, yeah.
Okay. So Mr. Powell was entitled to a defense tailored to his case, not to that of some long-gone generic defendant that may have happened in other cases.
Oh, no, he is, but the attorney who takes the attitude I just told you is making a judgment call as to what is going to work and what's not going to work. And he's been around for a long time, and the fact that this guy wasn't the lessee, he's going to say to himself, what difference does that make? And now the question comes, oh, well, maybe he could have impeached Wilson and all that, but that assumes that he knows all the lease, who's before and who's after and who's girlfriend and who's he going out with at the time. We have direct testimony that from Wilson that provides evidence of the enhancement. And as a consequence, he said, I got to go after that. That, to me, is a typical judgment call that a lawyer makes, isn't it?
Well, Your Honor.
If it's not a judgment call, then it's a question of, was it material? I mean, would it have made a difference if he had the lease? Would he have done anything differently? And would the court have come to any different conclusion? I think the court was convinced that the enhancement was appropriate, in view of what Wilson said. I'm sure impeach Wilson some, but does that mean you suggest that that would have thrown everything Wilson said out the window? When Powell himself confirmed a lot of what she said.
Well, yes, Your Honor. Here, since the government's evidence is, again, so slim, I mean, they're relying entirely for this premise enhancement on the hearsay testimony of a drug addict and a co-conspirator.
Yeah, but would have that added anything? If I'm a judge and you tell me the drug dealer didn't have a lease for that apartment, my reaction is, so what? It's his conduct. It's where he locates, and I mean, he may have had a colleague's, a friend's apartment or a girlfriend's apartment, and I must say, this is a very improvised arrangements, all these drug conspiracies, stash houses and so forth. There are arrangements that are put together for inconvenience with a fear of getting caught, and so anything that identifies them, the question is that a big deal? And I don't know, I guess your argument would be that a lease might undermine what Wilson said. Maybe, maybe not.
The lease would have undermined what Ms. Wilson said. Ms. Wilson's saying she's going to the same place for 5 years, and the lease is, again, only for a period of 5 months.
Yeah, but what was before, do we know?
That was never investigated by sentencing counsel.
Doesn't that make a difference?
Well, that was not put into evidence, what was happening at that apartment before. But a reasonably diligent sentencing counsel would have looked into that. And the sentencing counsel...
And so he's going to investigate it, he's going to go to the landlord and get who was in the lease before and get afterwards, and what the relationship, when Brown's relationship began with Brown and after it ended and all this stuff. And he's going to spend all this time when he's got 3 other enhancements he has to focus on, and that this one probably isn't going to make a hill of beans. That's what he's thinking, because so what, the drug dealer doesn't own the apartment. That isn't the issue in that appeal. The question is, did he maintain or control the apartment for use of drugs? And we have direct testimony that he did. And so your argument has to be, well, that direct testimony is so impeachable that it's I understand the strand.
Thank you, Ms. Maloney.
Thank you.
I want to thank both counsel for their fine arguments this afternoon. Ms. Maloney, my docket sheet doesn't show whether or not you or your firm were court appointed. I'm not going to make the inquiry, but you look to these old eyes as a younger lawyer who may or may not have appeared for the first time before a court. First time? You did a fine job representing Mr. Powell, and thank you for doing that, and your colleagues for allowing you to do that. And Mr. Kapoor, an excellent job as the representative of the United States. We're always aided when we have good lawyers helping us in these often difficult cases. We'll come down and greet counsel and adjourn for the day.
This honorable court stands adjourned until tomorrow